education requirements and the other life skill requirements of these children. So I mentioned earlier in the initial, when I showed the initial slide about the SOS model home for child sexual abuse survivors who are below 12 years of age, the really young ones, and there we have 3 SOS model homes: Thrissur, Ernakulam, and Palakkad, and where the ratio between the caregiver and the children is one SOS mother would take care of 8 children. And here again, the support services, the psychosocial support, medical care, and educational requirements of the child are taken care of. So level 3 home would be the mental health home, where children with psychiatric issues need specialized mental treatment, specialized psychological care. And we again have a mental health home at Thrissur. The special needs home is for children who have some kind of disabilities, and the facilities of the home are provided as per the requirements or as per the provisions in the RPWD Act, the Rights of Persons with Disabilities Act. Integrated care home, I mentioned initially itself, if the child survivor is impregnated, the child is referred to the integrated child care home at Trivandrum, and along with the legal needs, then the psychological support that is provided, the child is counseled, and the child is, the child and her family members are counseled, and if the child is willing to terminate the pregnancy, we make the arrangements for that. If not, we make the arrangements for the child to continue with the pregnancy. And systems are in place to ensure that the child, the newborn who is thus born, is also taken care of through rehabilitation and other support services provided by the department. Aftercare home, I mentioned again, we have 2 aftercare homes, one at Trivandrum and one at Ernakulam. Tejomaya home, we have one at Ernakulam, and I mentioned that, or I requested all of you to visit the Tejomaya home stall here at the conclave, and also to visit the home in Ernakulam. So this is some of the products. So what I was just trying to say in a nutshell is that the institutional support mechanism that we provide for child sexual abuse survivors is something which is, properly crafted, carefully considered, taking into account the trauma that the young child or the young woman has undergone, and the psychological support, the medical care, and the other healthcare needs are taken care of through the systems that we are providing in our homes. And here we have the support of the health department, the social justice department, the local self-government institutions, and some NGOs as well. And ultimately the call whether the child has to be placed in the institution or whether the child can be rehabilitated with society immediately is taken by the Child Welfare Committee. So therefore, when we give orientation to the Child Welfare Committee members, we include special modules on POCSO Act and other similar sections of law in order to make them understand and in order to make them appreciate the delicate requirements that these young children have, and how these delicate requirements are to be taken care of. We also have these one crisis centers or one-stop centers for for rehabilitating survivors of other gender-based violence cases, and one-stop centers are located within hospital premises because that would enable or facilitate the immediate emergency medical care and also legal and psychosocial support services in one roof. Then the other schemes that the WCD runs for, providing support to young women and young girls, and to empower young women and young girls, to provide support services to women who had been subject to different kinds of violence at home or outside. We have different schemes, the Ashwasanidhi scheme and Dhira scheme and similar schemes. Under the Ashwasanidhi scheme, we provide financial assistance, emergency financial assistance to these victims. Dhira scheme, we provide training in self-defense to children, to school-going children, to teenagers, and these different categories of children are provided training. In community-based rehabilitation, I mentioned about Kaval and Kaval Plus. In fact, in yesterday's ICPS session on ICPS, I had made a detailed presentation on how Kaval scheme is implemented. And Kaval Plus scheme is a similar NGO supported scheme for providing biopsychosocial care to children in need of care and protection. And this scheme has also been appreciated by the JJ committee of the state, of our High Court and the Supreme Court as well. So I'm not going into the details of these schemes. I will end the presentation here. In fact, I would have liked to spend more time with you and discuss the other provisions of other acts, and also to have a brainstorming session with the participants on the impediments in the implementation of certain acts, or the lacunae in certain acts, or the issues that we are generally faced with in the field. But I would entrust my team in WCD to have a brainstorming session with the participants after the invited speakers finish their presentation. But through this small 10 slide or 15 slide presentation, I was just trying to showcase or highlight the successful scheme that we are implementing here in our state. And we cannot say that this is an answer or a solution to the problem, but when we admit that there is a problem, we as the government department needs to ensure that systems are in place to provide succor to such victims. But the main responsibility of government, of the community, of society, of schools, of local governments would lie in the area where increased awareness is given to the community as a whole. Increased awareness is given to school children. Madam Dr. Elizabeth was mentioning about good touch, bad touch, and the different aspects associated with gender, associated with sexual abuse. So we need to focus more on training, on awareness programs, making youngsters, both boys and girls, aware about the various provisions of the Act, various provisions of POCSO Act, POSH Act, Domestic Violence Act, and other legal provisions that are available, that have been implemented, and also to sensitize the caregivers, sensitize the parents, sensitize the teachers. So therefore, under the aegis of the WCD, under ICPS, we have these parenting clinics, we have gender resource centers, we have block resource centers, we have district level resource centers, we run programs like ORC, but the reach has not extended to in the entire society or all the schools or all the sections of society. So that is where we are working in closer collaboration with the local government, the local self-government department as well. And we need a more coordinated activity with, or more coordinated strategy with the non-governmental sector as well, because this is a problem very often which is brushed under the carpet. So we cannot allow such problems to be brushed under the carpet. While we give awareness to our children, to our youngsters, we also need to strengthen the systems that are in place at the field level and at the community level. So I would end here, and I would look forward to the deliberations, the summary of the session from which we would get, some action points on which we can, work out newer strategies and newer interventions. So thank you very much.
Thank you, ma'am, for the addressing. Now, may I please call upon Ms. Premna Manoj Shankar, District Women and Child Development Officer, Palakkad, to express a gratitude on our behalf.
Morning, everyone. As all of you are aware, 3 different seminars are going on simultaneously in this venue, and Sharmila Madam has been dividing whatever little time she has among the 3 seminars that have been going on, and we are very glad to have her here because she is someone who can, because from yesterday and today, we have been listening to experts telling us that what is currently going wrong in our efforts and what can be done to correct them or make it better. And Sharmila Madam is one of the few people here who can make a difference in that area, because she has the ear of the policy makers and she is in a position where she can implement many of the things that the experts have given us as problem-solving steps. So, Madam, on behalf of all of us here, we thank you both for your presence here and also for the very brief and concise presentation you did regarding the measures that we have for the safety of the girl children from WCD department. Thank you, ma'am.
Thank you, ma'am. Before we move on to the next session, we have a few questions that's been addressed to the Honorable Justice, Sir Kausar Edapagat. Sir will be briefly explaining those.
3 brilliant questions. Congratulations to the author. First question is whether a person can file a complaint under the POCSO Act after attaining majority. Victim. For example, if the person is now above 30 years of age and living independently, can they still report an offence that happened during childhood? Also, does any period of limitation apply to cases under the POCSO Act? How to prove such offences before the court? 2 questions. First one, can a person file a complaint after so many years? Can a victim who was sexually assaulted during her minority could prefer a complaint under the POCSO Act against the perpetrator after she attaining majority and after a lapse of considerable period of time? Is there any limitation? That is the first question. And second, how to prove if that is permissible? See, criminal law, POCSO Act also is a part of criminal law. In criminal law, to set the law in motion and take the cognizance of the offences, a period of limitation is prescribed under the erstwhile CRPC and the present BNSS. But for offences which is punishable more than 7 years or graver offences, there is no period of limitation at all. Small offences, 1 year, 2 year, 3 year period of limitations. So offences under the POCSO Act, which falls under the category of serious grave offence, there is no limitation period at all. At any time you can invoke after attaining majority after so many years. And we often see there are cases where POCSO Act, most in incest cases, the sexual assault by close relatives, especially step parents and parents, the victim would not open up, or else he would have spoken to mother, but due to various reasons mother would not initiate an action. Then it normally comes out after few months or years, when it is disclosed to relative, friend or to school authorities, then case is being registered. So in this example, it is now above 30 years. So more than 12 to 13 years have been elapsed. It is maintainable, law can be set in motion, but the see, why such a long delay has to be reasonably explained if you want to convict that person. If that delay is reasonably explained, in most of the rape cases, coercion, threat, etc. is the reason shown for the delay. If that is properly explained, delay. So, if delay is properly explained, the accused could be convicted. How to prove such offences before the court? Answer is, in sexual assault cases, as Madam Elizabeth said, it most often happens in a closed rooms, etc. In incest cases in own home. So you won't have any other, you can't expect any other evidence in rape cases. Very quite unlikely that rape take place in public places. So you can't expect a corroborative piece of evidence. Mostly the victim's evidence, unless it is impeached and is believed by the court, sole evidence of the victim is sufficient to prove a POCSO case. But if there is an unduly delay, that evidence should be strong enough. That is the first question. I think I made it clear. And second question is very interesting. If both the victim and the accused are minors, at the time of the incident, can both claim the protection or immunity available to children under the law? In such a situation, if the act was consensual between two minors, will the boy still be prosecuted under the POCSO Act? Or does the law treat both parties as children in need of care and protection? See, first of all, POCSO Act is a gender neutral legislation. Right? Even if boy, even if a girl sexually assault a boy, girl can be booked, right? But if you read at the offences which start from section 5, child is defined under the act as a person aged 18 years, be it a girl or boy, whoever it is. See, when you read the section, a person commits sexual assault on a child, whoever commits sexual assault on a child. So basically, the intention of the object of the section is to protect the victim child who is below the age of 18 years, and probably the perpetrator should be beyond the age of 18 years, right? But an offense can be committed by a child also. That is, to deal with child delinquencies, there is a separate legislation called Juvenile Justice Protection Act 2015. There, the accused is not treated as an accused, but child in conflict with law. Then, even a consensual sexual act is an offense. But consensual, who gives consent for sexual act? Minor gives consent for sexual act to a major. Then that consent is not treated as a consent in the eye of law. Then it has to be treated as a sexual assault without consent, right? But both of them are minor. Interesting question. I think it has not come, Srila. It has not come before any court. So both of them has to be treated as a victim, and both of them could be treated as an accused as well. So ultimately, even if the case is filed, they should be dealt with under the Juvenile Justice Protection Act. As a child in conflict with law, they have to be rehabilitated and treated under the Juvenile Justice Act. And third question is, can a fundamental rights be relinquished, waived? Answer is an emphatic no. See, these rights fundamental rights protected under Part 3 of the Constitution are considered as matters of public policy and essential constitutional safeguards rather than a personal privilege. It's not a personal privilege. So even if a person consents to relinquish them or waive it, it's not possible. It's covered by a decision, a celebrated decision of the Supreme Court. I think the author of the question is a law student. You can go to Basheshar Nath versus CAT. It's a 1959 judgment, Basheshar versus, specifically held that fundamental rights cannot be waived. Thank you for the question. If any more questions, I am happy to answer. I will not be here in the after lunch because I have some health issues. I can't stand long. So, thank you. Parnod, cholo. Mic and dog.
Thank you, sir. You have mentioned about 3 criminal laws, BNS, BSA, and Bharatiya. Is it correct? BNS, BSA, and Bharatiya Nagari Suraksha, right? Okay. Then in BNS, adultery is removed. It's a criminal offense removed from the BNS. So I need your opinion. Is it welcoming or is it good for society? Thank you.
Even before BNS, adultery is declared as the offense. Adultery offense 3.
I think 496.
Even before that, that was declared as unconstitutional. Okay. Even before BNS came into force, the adultery has been declared as unconstitutional by the Supreme Court. See, initially the Delhi High Court took the view that in Indian, our cultural diversity and adherence to religious ethos, etc., adultery is a serious sin and offense. But later on, Supreme Court took the view that society has changed a lot. Any consensual relationship, even with a married woman with a married man, cannot be cannot be termed as an offense, but it can only be a ground for divorce. That's all, because it's basically a consensual relationship. So any moral offense can't be treated as a criminal offense unless and until it is. And see why the Supreme Court is declared it as an unconstitutional, for the reason that it violates Article 14. Because in adultery, the wife, female partner is treated as a victim, and male alone could be prosecuted and convicted. But both are at fault. In most of the cases, or some of the cases, at least few of the cases, female takes the initiative. Then she is treated as a victim, husband is booked. That is the reason it was struck down by the Supreme Court, and now it has been taken away.
Okay, sir.
Thank you.
One more question. You mentioned these awareness, all these awareness where you have been conducting outreach organized is not useful for the society. So my question is, if the judicial system is strong, all these can be eliminated. I think so. So what is your opinion in prima facie in this context?
Do you think that judiciary is not strong enough?
Actually, I don't know. Actually, in my experience in Kerala also, even in North India, we know the current scenario, what is going on. So that's why I was...
See, a collective, collaborative effort is necessary, right? First of all, we should have a strong law, correct? Second, we should be able to implement that strong law. Thirdly, we should be able to, when a person is prosecuted under that law, we should have a strong, the judiciary to deal with that accused. Then fourthly, the correctional execution, etc. Above all this, see, a sincere effort and participation of each and every citizen of the country is the most important. See, judiciary has certain limitations, especially in criminal laws. We are guided by our constitutional principles. We have a set of norms and laws which we are bound to follow. See, our criminal jurisprudence is based on the premises that an accused is to be presumed to be innocent till he found to be committed an offense by a court of law. പിന്നെ അറിയാലോ 1000 കുറ്റവാളികളെ ശിക്ഷിച്ചാലും ഒരു നിരപരാധിയെ പോലും 1000 നിരപരാധികളെ ശിക്ഷിച്ചാലും അങ്ങനെയുള്ള ഇതൊക്കെ അറിയാലോ. പിന്നെ the entire burden is on the state prosecution to prove the case, and even the accused has a constitutional right of silence. ഒരു ഇപ്പം ഒരു പുതിയ നിയമങ്ങളൊക്കെ ഒരു മാറ്റമുള്ളത്. ഇപ്പോൾ പോക്സോ ആക്ടിലൊക്കെ ബേർഡൻ മാറ്റി റിവേഴ്സ് ബേർഡനൊക്കെ വന്നിട്ടുണ്ട്. ഇപ്പം ഈ NDPS ആക്ട്, ഈ നാരോക്കോട്ടിക് ഡ്രഗ്സിൻ്റെ ആക്ടൊക്കെ കുറേ നിയമം മാറി വരുന്നുണ്ട്. അപ്പോഴേ അങ്ങനെയുള്ളൊരു സെറ്റപ്പിൽ വെച്ചിട്ടാണ് നമ്മൾ തെളിയിക്കേണ്ടത്. അപ്പം ഒരു കുറ്റം ആരോപിക്കപ്പെടുന്ന ഒരു വ്യക്തിയെ അക്യൂസ്ഡ് അയാളെ ശിക്ഷിക്കണമെങ്കിൽ യു ഷുഡ് prove the case beyond reasonable doubt. How to prove a case? To prove a case, first of all, investigating agency has to collect sufficient materials. Then the prosecution agency has to present the case, that materials before the court and convince the court. Suppose investigating agency failed in collecting the materials, court is helpless. Suppose investigating agency collected but prosecution agency failed to present it before the court, court is helpless. We are following the separation of powers, executive, legislature and the judiciary. One can't interfere in the sphere of the other. So അതുകൊണ്ടാണ് നിങ്ങളിപ്പം പറഞ്ഞ ഡൗട്ട് വരുന്നത് ജുഡീഷ്യറി സ്ട്രോങ് എനഫ് അല്ല. ജുഡീഷ്യറി ഹാസ് ഇറ്റ്സ് ഓൺ ലിമിറ്റേഷൻസ്. ജുഡീഷ്യറി can act within its the four corners, but to the extent possible we are doing it. Of course, especially in a democratic setup, because entire power is vested with the judiciary to exercise the power of judicial review on administrative and executive actions. Unless a judiciary is strong in a democratic subject, nation cannot survive. You are absolutely right. Judiciary has to be strong. But അത് മാത്രമല്ല, ബാക്കി എല്ലാവരുടെയും including the participation of each and every citizen of this country is necessary to maintain the public law and order. Right.
Thank you, sir.
Thank you. I think no more questions. Thank you. I'll be leaving.
Let me express our sincere gratitude to the Honorable Justice for patiently answering the questions and giving clarity and the answers and addressing the audience. Thank you so much, sir, for the extended time as well. Wishing you good health. Let us move on to the next session of the day, which is by Ms. Shobha Gupta, Senior Advocate of Supreme Court of India. Let's welcome her onto the stage. Ma'am, welcome. She's a distinguished lawyer in the Supreme Court of India and a tireless voice for human rights and women's justice. Beginning her legal career in 1995 at the Rajasthan High Court and practicing in the Supreme Court since 1997, ma'am has handled an extraordinary range of cases from constitutional law and public interest litigations to criminal justice, environmental law, labor matters, human rights and gender justice. She has served as standing counsel for several public institutions and represented the National Human Rights Commission for over 2 decades. Beyond the courtroom, she is a founder of FLAG, Free Legal Aid Group, and the social platform We the Women of India. Initiatives dedicated to legal aid, women's rights and social justice. Her interventions have addressed critical national issues including violence against women, illegal adoptions during COVID, child rights and institutional reforms. And her relentless 21-year pro bono legal battle in the Bilkis Bano case stands as a landmark in the fight for justice, resulting in historic compensation and the return of the convicts to the prison. In recognition of her exceptional contribution to law and justice, she was designated Senior Advocate by the Honorable Supreme Court of India in 2024. May I take this opportunity to invite her for the talk of the conclave on day 2. Ma'am will be talking on the subject implementation of PWDV Act and Dowry Prohibition Act, legal strengthening. Welcome, ma'am. Over to you now.
You can take all this. No? Hello friends, now the hall is empty it seems, and I inquired, the gathering is broadly of the people from WCD and then few law students I guess, right? The subject given to me was to speak on the protection of women from Domestic Violence Act, Dowry Prohibition Act, the implementation, and the lapses, if any, or what can we do to strengthen that. Not in view of the fact that we are already too late, you people might be hungry, and the session time is already over. I would try to finish this quickly. Okay, I am not going to now deliberate upon the sections in detail. I'll just give you a quick view why we had to have in 2005 an act called Protection of Women from Domestic Violence. We already had by then section 498A in IPC that deals with dowry, dowry death, and that was declared as an offense. We already had Family Courts Act, which were dealing with the cases involving divorce, maintenance, any other protection a woman needed. We already had Hindu Marriage Act, for that matter Muslim Marriage Act, for that matter Special Marriage Act. So broadly, as a law student, you should be having that question. As a WCD members, you should be having that question, why we had to have that. We already have enough laws by then with us. But then in United Nations, you had that CEDAW, right? Convention to Eliminate Domestic Violence Against Women. India was the signatory of the same, and the major thing was all these criminal cases, the divorce cases, the maintenance cases in civil courts, the criminal cases in terms of the maintenance under section 125, all were taking enough time. Given the nature of the act, if this is a 498A, a dowry case, or some violence to a woman for want of dowry by the in-laws, the women were susceptible to go to police station, lodge an FIR, register a case, visit police station again and again, give their statements over there, and get subject to their in-laws or their parents-in-law, the husband, everybody else, to a criminal jurisprudence. Sometimes, you know what happens? A woman who is being targeted, violated, harassed, subjugated, want to address her trauma, the violence caused to her, subjected to her, but do not want a criminal proceedings to be initiated against her husband or the in-laws. So the legislature had to thought of a via media, decriminalizing the few of the aspects, giving the choice to the women whether she wants to go to a criminal proceeding or she wants to go to a civil and quasi-criminal proceedings. Thus came this Domestic Violence Act. The idea to provide, I'm just using the term Domestic Violence Act, or the name of the act is quite lengthy. Idea was to provide the remedy of justice at the doorstep. And therefore, you have the provision where the nearest magistrate would be empowered to take your case, register it. Now, what is domestic violence? That area was not covered by either the Divorce Act, Hindu Marriage Act, for that matter, 498A, is my violation when it comes to restraining my movement, restraining my financial freedom, caging me in various ifs and buts, yes or no. all that now, emotional trauma, monetary trauma, physical trauma, refusal to go for an employment, all that could be covered under the Domestic Violence Act. So a woman, even, you might be a person who is actually going to job, there is some harassment, you feel there is a harassment, the in-laws might not have done that. Sitting in the comforts of your home or sitting in the comforts of your office while working, you can just send a mail. You can just send a complaint. You can just call upon 181. You can just call upon 112, which is now a centralized number. From there, the law would take its own course while you are still continuing with your daily routine. You need not to go to a third place. You need not to wait in a police station for 4 hours. You are still not putting your marriage at threat if you are so willing to pursue with that. That is the concept of Domestic Violence Act. Now, assume there is a violence in actual nature, bodily violence. What to do? So, just completing the first one. So, there is a concept of protection officers. I must tell you, Kerala is doing fairly well. We have filed a matter. I am running an NGO called We the Women of India. We filed a petition in Supreme Court, that is a public interest litigation in 2021. This act is 2005. We are now, this act is major. It is 25 years old act, no, 21 years old act now, right? But still the implementation in the entire country, including your state, is also a far cry in terms of the real implementation. When it comes to each and every woman and man knows about the provisions of the act, and this is what, when we are discussing this, since we are doing with WCD, please take note, where we fail. In India, there is no dearth of having great legislations. The provisions are exceptionally good. Where we fail is the real implementation. If today, with all due respect, I am talking not against anything, if somebody has to now in 2026 show you a PPT in this hall to inform you what all is being done, then raise 100 questions, where are we failing? Is the implementation going good? If your implementation is going good, then Section 11 of the Domestic Violence Act requires the central government as well as all the state governments to spread information about what? About the provisions of the Act, what all can be done under the Act, and the measures taken by the respective governments under the Act for the purpose of providing protection to every single woman sitting in urban area, rural areas, or on the fence. With means, without means. If she is without means, this is the duty of the government to create means for her. So if the WCT people who are sitting here are sure about the fact that if they go and meet 10 women in their vicinity, and 10 of them says we are aware of the Protection of Domestic Violence Act, you need not to bother, then you are a success. If out of 10, even one says what is that, then please put a question and do something for the spreading of the information. Like when we were growing up, we used to see in the TV about don't smoke. That's injurious to health. We are taught in schools, don't lie. That's not good. The moral lessons. We don't have moral lessons about a married life. We don't have moral lessons when it comes, even if the woman is not married. It's not about married women alone. Domestic Violence Act is not meant for married women alone. If your father, your mother, your brother, your sister, or anybody in your family stops you from doing what you want and you feel you are violated, the act comes into play. So are we informing, have we done enough under Section 11 to spread the information? If we have yet not, then let Kerala become the first state to do it. See, there are few implementations on your PPTs. There are few implementations on your papers. Yeah, there are few implementations on the file of the department. I am talking the real implementation, where every single woman or man walking on the street is aware of that. Like, who would say we don't know that speaking lie is wrong? Who would say we don't know committing murder is a crime? Who would say raping a woman is not a crime, we don't know is a crime? Similarly, about the provisions of Domestic Violence Act, let us take it as a mission. You become the first state to do it, to spread the information, be it through the police stations, Anganwadi workers, you must be having different nomenclatures here, through the department itself, the protection officers. Why having one protection officer, one district? Can a single protection officer handle all the cases of that district? It's an impossibility. Why? Because the protection officers is required to do what? Attend the phone call, do the counseling at home. If there is a call under 112 or there is a call under 181, the protection officer is supposed to visit the woman at home, do the counseling, file the complaint for her. If she is physically harmed, take her to the medical facility nearby, get a shelter home for her, get her home stay, ask for the maintenance before the magistrate, file a complaint for her. This is a whole lot of tasks. Each protection officer has to do the hand holding for that victim woman. So why not, I'm asking this question and making a suggestion, not having pro rata basis protection officers in each district. It depends on the frequency of the complaints, even on the phone call. It's not about the registered complaints. Most of the time we get the data about the registered complaints. If you are getting 100 phone calls by women and there are only 3 complaints lodged in a day, how are we considering this data? Is 3 the right number, or it is 103 the right number? So we have to put this question and do some effective real work. You know, so each one of us are being paid. If we are working for the department, paid. Department is supposed to do something. The protection officers are paid, supposed to do something. Their hands are normally full. Add more number of people, get the real work done. Now, if not something which has not been done in last 21 years, try to get it done now. Make your state as a role model, which is role model in many ways. I must tell you, in the petition which we have filed in Supreme Court, Kerala is possibly having the best affidavit to be filed. Kerala is possibly the state where they have the post sanction for protection officers. But then don't engage them on temporary basis. Don't give them additional charge. There are few of them who are having additional charge. There are few of them who are actually on the temporary deployment. There are only few, 5 or 6, who are on out of 14 on permanent basis. Permanent basis, more number of protection officers. Similarly, service providers, none of us are paying heed to service providers. Service providers should be there. The training should be in real term. Have pocket of areas, train the women, men and women both. I was doing a session in a village once. There was a retired High Court judge sitting. And when I was talking about protection of domestic violence and how a woman should take recourse to save her or to look for her rights to be protected, ask for maintenance, whatever. So the judge said, I think we should not be informing much about the act. It might break the families more. Now come on. If knowing about the right, you know about fundamental rights stated in Part 1 of the Constitution, does that break anything? No. You know your right about the salary to be paid to you, the work to be allotted, the time in the office. That's not breaking up anything. So being aware of the right provided in the Act, because of the Constitution and the Act, it's good for all of us, good for the state, good for the government, good for the system, good for the people who are suffered, and good for the people who are otherwise can subject someone to any kind of violation. Making them aware of that these are the violations, you can be booked, you would be asked to make maintenance to be paid, then further action can be taken against you, and then this is the requirement of the law, and the morals would always be helpful. So this is the Protection of Women from Domestic Violence Act. There's another area which if the state can do something about, to come out with some kind of notification, circular, or some kind of amendment. In Domestic Violence Act, once the woman files a complaint or an application for interim relief, Act says from the date of application of filing, within 60 days decide the applications. Section 12(5). None of the courts pay the heed. The dates are given some 6 months ahead. The applications are decided in years together. Assume for a woman who has just come out from home because she was badly beaten in the home. She comes to a police station or calls upon a protection officer, is given a shelter for 3 days. The shelters are being provided for 3 days or 5 days for maximum. Now, where from shelter home, where would the woman go? What is the state doing for that? Where would that woman go who has come out after being violated badly at home, reached to the police station or the protection officer, provided a shelter home for 3 days or 5 days? Still there is no resolution because no maintenance given. Police would take its own time to register the case. Magistrate would take its own time to proceed further. Where would that woman go next? We are not answering that. When we are not answering that, the woman would continue to remain in the very same house, continue to get violated, because at the end of the day, she needs a shelter, a roof on head to sleep in the night, 2 times meal to fill her stomach. Unless we are not answering that, unless we are not practically addressing that, we would keep doing the lip service, we would keep patting our back saying we are doing great job, we would keep creating the PPTs, we would keep doing these seminars, and at the end of the day, we would be knocking the another seminar to do. If in 21 years we are still doing seminar on implementation and still further steps to be taken, we have to ask 100 questions to us. By this time, this act should have served her purpose. By this time, we should be arguing why we are having this act anymore. By this time, there should have been all answers written on the books. So let us now get up, pull our socks, and do what is actually essentially required. So one is, the moment a complaint, stay has to be longer subject to the need of the woman in the shelter homes. There should be many shelter homes in each district. A woman would not be in the night walking 10 miles to reach to a shelter home. Create as many as the state can. Those women can then put for some temporary jobs, maybe become you caretaker or something else in the same shelter home. Do some stitching, do some other things. Somebody might be knowing teaching, somebody might be knowing something else. They can then become the manpower to work for the departments. Don't throw them off after 3 days or the 5 days. Ensure the continuity of shelter 1. Ensure that they get the immediate succor. That is the immediate maintenance. The moment they come out from home, most of the women are not saving money in the floor, dabba or somewhere else. It's not as if everybody has some money and whatever money you could have saved would last not many days. So there has to be a provision for immediate succor to the woman once she is out. She might be having 2 children. Now your shelter homes, assume for a moment she has a boy of 15 years of age. I'm asking the question to the WCD people. If a woman comes out of home, beaten badly, she has 2 children, one minor girl who is 8 years and a minor son who is 15 years. Where would those 2 children go? I know the answer from you, that the girl would get the shelter there. What would happen to the boy? Where would the mother leave that boy? We don't have the answers for these things. Unless we find out answers, the woman would actually by force continue to live in the same house, continue to be beaten up or suffer, but not come out, take benefit of the act. So let us try to put real questions, do some questionnaire amongst, broadly, and try to find answers. The interim maintenance application must be decided in 15 days. The final maintenance application must be decided in a 6 months' time. There are provisions of appeal, but there should not be any stay unless the husband pays 50% of the amount at the threshold. The appeal should not be entertained as a matter of rule unless he pays. And the moment there are 2 dates of skipping payment, make sure that his property is attached or something is done so that the amount travels to the woman. Unless we are doing some tough things, we are not reaching further. I'm not addressing the Dowry Prohibition Act because that's the 1961 Act. If we are still suffering dowry prohibition, my very, very clear message to you all is, I know Kerala had some brutal cases of dowry death. 2-3 years back, there was a horrific incident. But then what are we doing as a department or as a society? Why are we not spreading the word further? Marriage is not an essentiality. Make sure you are getting your daughter married to the right place where not a single penny is asked for dowry. Don't give dowry because you love your daughter so much and therefore you want to, show the extravaganzas. Keep that money intact with you. Pass on that money later on to her account. Give her the decision, the choice to use that money whatever way she can. If you have extra money to be given after the marriage extravaganzas to her, don't give the dowry in terms of actual dowry. Wait for years when the marriage survives. The FDs would be there. Make 10 years FD so nothing is coming immediately, with the provision of no breaking up FD in between. And girls, please say no for dowry, Baba. Why do your parents are educating you? Why you have to allow that? Act came in 1961. Now, unless we stop paying it, we stop this culture, incidents would keep happening. You might punish somebody within 6 days or 6 months or 1 year. You can't spread that word the whole society, so to say, since he was punished, now you would be punished, don't ask for. Stop paying now. Make it a rule, every single young girl, every single mother, that come what may, whether my daughter is getting married or not, my first condition for a groom is, are you asking for dowry? Sorry then. Earn your money, let the girl earn her money, make the life, no begging, no bonus, right? I think since everything is got so extended, I am not really looking to extend the time and harass you people for you must all be waiting for lunch. Thank you so much for having me. It's a pleasure. And questions we can do later, I guess. Go and have lunch. Thank you.
Thank you, ma'am, for your valuable time and sharing your thoughts. May I please call upon Mrs. Asha Molkevi, the District Women and Child Development Officer, Pathanamthitta, to kindly express the gratitude and also give away the memento.
Respected Speaker, Ms. Shobha Gupta ma'am, Senior Advocate in Supreme Court, and respected audience, strengthening of Domestic Violence Act and Dowry Prohibition Act നമ്മളുടെ സൊസൈറ്റിയിൽ 21 ഇയേഴ്സിന് മുകളിലായി വന്നിരിക്കുന്നതും 1961 തൊട്ട് പ്രാബല്യത്തിലുള്ളതുമായ ഡവറി പ്രൊഹിബിഷൻ ആക്ടിനെ കുറിച്ചുമാണ് മാഡം ഇവിടെ സംസാരിച്ചത്. നമുക്ക് കുറച്ചും കൂടി അവയർനെസ് ഈ രണ്ട് നിയമത്തിൻ്റെ ഭാഗമായിട്ടും കുറച്ചുകൂടി അവയർനെസ് നമ്മളുടെ സൊസൈറ്റിയിലേക്ക് ചെല്ലേണ്ടതായിട്ടുണ്ട് എന്നുള്ളതാണ് മാഡം നമ്മളോട് സജസ്റ്റ് ചെയ്തത്. അപ്പോൾ WCD ഒഫീഷ്യൽസ് എന്നുള്ള നിലയിലും ഈ നിയമങ്ങൾ ഇംപ്ലിമെൻറ്റ് ചെയ്യുന്ന ഒരു ഡിപ്പാർട്ട്മെൻറ്റ് എന്നുള്ള നിലയിലും നമ്മൾ കുറച്ചും കൂടി സൊസൈറ്റി അവെയർ ആക്കേണ്ടതുണ്ട് ഈ കാര്യത്തിലേക്ക്. അപ്പോൾ നമുക്ക് ഇത്രയും ഒരു സെഷൻ എടുത്തു തന്ന നമ്മളുടെ ബഹുമാനിയായ ശോഭ ഗുപ്ത മാഡത്തിന് on behalf of Kerala Government and Women and Child Development Department, we express our sincere gratitude and thanks to ma'am. Thank you.
Ma'am, can I please have you on stage once again? We need to express our love in the form of a small memento. ഈ ഗിഫ്റ്റ് ഹാമ്പേഴ്സ് എല്ലാം തന്നെ നിർഭയ സെല്ലിന് കീഴിലുള്ള തേജോമയ ഹോമിലെ കുട്ടികളാണ് ഉണ്ടാക്കിയിരിക്കുന്നത്. ഇവരെല്ലാവരും തന്നെ ലൈംഗിക അതിക്രമത്തെ അതിജീവിച്ച് വന്ന കുട്ടികളാണ്. ഇന്നലെയും ഇന്നുമായി എല്ലാ വേദികളും വരുന്ന ഗസ്റ്റുകൾക്ക് നൽകുന്ന ഗിഫ്റ്റ് ഹാമ്പേഴ്സ് എല്ലാം ഈ കുട്ടികൾ ഉണ്ടാക്കിയത് തന്നെയാണ്. താങ്ക് യു. Now we break for lunch and we will be getting back to the afternoon sessions in 30 minutes of time. Requesting all of you to എല്ലാവരെയും മുന്നോട്ട് കടന്നിരിക്കാനായിട്ട് അപേക്ഷിക്കുകയാണ്. Kindly occupy the front seats because there are so many vacant seats in between. So can I have most of you to the front side? Let's not have any vacant seats. എല്ലാവരും മുന്നിലോട്ട് കടന്നിരിക്കുക. ഏറ്റവും പുറകിലിരിക്കുന്നവരൊക്കെ മുന്നിലോട്ട് കടന്നിരിക്കൂ. വരൂ, മുന്നിലോട്ട് വരൂ. വന്നു കഴിഞ്ഞാൽ അവർ ബാക്കിലിരുന്നോളും. മുന്നിലോട്ട് വന്നോളൂ. വരൂ, എല്ലാവരും മുന്നിലേക്ക് വരൂ. ഇവിടെയുണ്ട് ഫാൻ, ഇവിടെ ഉണ്ട്. എല്ലാവരും ദയവായി മുന്നിലോട്ട് കടന്നിരിക്കുക. Because our guest speaker is here since morning, so let us give her some respect. Kindly, all of you, please move to the front seats. We are slowly moving on to the afternoon session. It's my privilege to introduce Dr. Sheba Ifdar, Professor at the National University of Advanced Legal Studies, Kochi, and Director of the Center for Women and Family Studies. She's an outstanding academic achiever. She has secured top ranks in both her LLB and LLM from the University of Kerala, and has been honored with prestigious distinctions including the Mallur Govindapillai Gold Medal and the Justice M. Fatima Bibi Law Graduation Golden Jubilee Prize. She earned her PhD in law on the critical subject of domestic violence against women, focusing on legal and judicial responses. Since joining the NUALS in 2009, she has made significant contributions to legal scholarship, authoring and editing several books and publishing widely in national and international journals. Her expertise extends beyond academia into institutional roles, promoting safe and equitable spaces. She serves as presiding officer of the internal committee at NUALS and as an external member of internal committees in major institutions, including the Gale. Her work reflects a deep commitment to women's rights, legal reform, and gender justice. Today, ma'am will be talking on the legislation for empowering women at work, review, and strategies. Welcome, ma'am. I again request all of you to kindly occupy the front seats as a respect to the speaker. Thank you. Welcome, ma'am. All yours.
Good afternoon, one and all present here. I have a small PPT, though it is 18 slides. I'll compress it to the most extent possible because I have learned from my students that the audience or the learners will take only what they really want. That is something which I learned from the students because always teachers teach us, but the reverse process is taking place nowadays. So I'll stick to that also. Optimizing labor legislations, empowering women at work. Okay, starting with a tribute to Dr. B.R. Ambedkar, whom we all know as the chief architect of the Indian Constitution. Simultaneously, he is the chief architect for labor reforms, or rather we call labor legislations. In fact, he has introduced as a few labor law students are also here, I believe. In fact, we know the tripartite approach is one of the key elements in labor reforms or labor laws. It is one of his innovation, tripartite approach. The inclusive approach, inclusivity in the sense, including providing opportunities, providing for the deprived, the marginalized section, which includes women also. Then the third point, the social security or the life cycle approach, social life cycle approach in the labor legislation. These are the three aspects which is the contribution of Dr. B.R. Ambedkar. Now, obviously, when I talk about the Constitution, a reflection on the Constitution of India, as you know, I have put in a diagram itself. See, we know there is one Article 39 you all know about the fundamental rights, Mauli Avgasham. Article 39 is not coming under the fundamental rights. Instead, it comes under the directive principles of state policy. That means it is not a right specific. If there is any violation, you can approach our High Court or the Supreme Court for direct enforcement through writ. Instead, it is a directive principle. Why it is given in the form of a directive principle? Because it depends on the economic capacity of the state, each of the states. So it remains under Article 39. Article 39, we call it as the Charter of Labor Rights. Charter. Yes, our ma'am was talking about the SIDA, the Convention of Elimination of all forms of discrimination against women. In fact, it is a charter of women's rights. Likewise, Article 39 in our constitution is the Charter of Labor Rights. It talks about everything relating to laborers generally, respective of men and women. Equal remuneration for equal work, which you could see under the specific statute, Equal Remuneration Act. Then you could also see the elements of protection of motherhood, maternity, under the same Article 39. I was referring to this point, Article 39. Then protection of youth, childhood, preventing child labor, non-concentration of wealth, that is against capitalism, equitable distribution of wealth. All these are coming under Article 39. So we call it as Charter of Labor Rights. Then coming to Article 42, creating a just human conditions of work, including maternity. So other things, Article 43A, that is one of the another important thing, 43A. Do you believe every employee has a right to say in the management of the establishment? Right to speak, right to have a say in the decision-making process? You have heard of it. That is right to co-determination. That is again mentioned under the directive principles of state policy, not a fundamental right. But as I said, economic capacity of the state, depending on that, it could even be converted to fundamental rights. But it is being incorporated in a number of legislations. Just a glimpse, and a summary of the constitutional provision. Again, 43 living wage. Are we as employees, not excluding students, are we as employees receiving living wage? Are we receiving living wage? It is a different concept. It is nowhere encompassed in any of the statutes, living wage. Right now through the code only, we have seen 4 labor codes introduced. It is a major reform that is recently introduced. That is why we could see a number of seminars being organized. Even the labor code does not talk about living wage, and living wage is the constitutional aspiration. What the labor code says is about floor wage, and the floor wage is fixed by the central government, and the minimum wage fixed by the state government should not fall below the floor wage. So the concept of floor wage is coming, minimum wage is coming, but nowhere the concept of living wage. So minimum wage is at the lowest level, just above it is the fair wage, just above it is the living wage. So living wage is the highest one. No legislation confirms anyone with living wage. It remains as a constitutional aspiration. So nothing especially to be told about women. Now moving to Article 14, as you know, again the equal remuneration, equality between men and women, no discrimination. Now moving specifically to the legislation. These are some of the legislations conferring certain status or legislation specifically empowering women, whereby the women's participation in the workforce could be enhanced. Like first one, Equal Remuneration Act, I made a reference to when I was referring to the statute constitution. Maternity Benefit Act, I did. Factories Act, Shops and Commercial Establishment Act, then the Sexual Harassment, which we often name it as the POSH Act. So I have highlighted the 3 statutes because I will be concentrating on the highlighted one. The other 2 are also 2 legislations talking about the conditions of work of women employed in factories and establishments, basically talking from the point of working hours. I'll come to it later. Now, this is the life cycle approach. As an employee, consider you as an employee. Basically, 3 stages are there in your employee's life cycle. First one, onboarding stage, right? That is the recruitment stage. You're giving, so you are now my employee. Recruitment stage, then onboarding. You are taking into my establishment. Then the final stage, exit stage. This is the primary 3 stages in the life of every employee. Do you believe that we have sufficient legislation to protect the employees at all the 3 stages? If you go deep into the life cycle, the second diagram gives you the deeper analysis of the different stages. But everything coming under the primary 3 only. So let's say with respect to onboarding. Once you are once you are engaged as an employee or appointed as an employee, what are your rights? Just consider it from the point of a woman. What are your rights? As an employee, you've joined your establishment. You should be made aware of your right as an employee. And if you are a woman employee, first right you get maternity. Even prior to that, an appointment letter should be issued. That should be issued to all irrespective of the sex, gender. But as a women-specific labor legislation, I am saying you should be informed by your employer as to your right to get maternity benefit, being women. Even otherwise, all employees should be informed of your primary rights under different statutory rights specifically. Okay, now, it's not moving. Slide is not moving. Yeah. So section 3, CSS, that is the code I was referring to. That is one of the codes, Code on Social Security, that has subsumed the Equal Remuneration Act. So same work, similar work. If the women and men, they are doing the same work, both are entitled to get the same salary. Are you of the opinion that with respect to recruitment and with respect to conditions of service also they should be treated equally? Is that right also conferred through this statute? Because from the statutory name, title, that is not reflecting. So many of the employees, even employers don't know that recruitment and conditions of service, in that also equality should be maintained. So that is another thing. If we are ignorant of that, that is also there. Not only with respect to pay, with respect to recruitment and condition. Recruitment stage, once you find that the employer finds that a pregnant lady is there and a man is there, the employer will be interested in appointing whom? As a human, as a basic human, going by the basic human nature, he'll be going for the male. Why? Because she may be, soon after joining, she may be seeking maternity benefit. That thing will prevent him from appointing. So at the recruitment level, also there is a right. There shall not be any discrimination. Now, something critical is there with respect to the provision. Make any discrimination on the ground of sex while recruiting any employee for the same work or work of similar nature and in the conditions of employment, except where the employment of women in such work is prohibited or restricted by or under any law for the time being enforced. 3 conditions I said: recruitment, no discrimination; payment, no discrimination; and with respect to conditions, no discrimination. But the last highlighted one says that if there is any other law which says that there shall be restriction, all the rights are subsided. So there comes the Factories Act and the Shops and Commercial Establishment Act, which restricts employment of women between the time from 6 p.m. and 7 a.m. Let me check. It's not moving. It takes time. That will be better. Yes, yes, yes. This is the next slide later. Okay. Yeah. Section 66, subsection 1, clause B of the Factories Act. It restricts the employment of women between it allows only between 6 a.m. and 7 p.m. That is after 7 and between till 6 a.m. there shall not be any employment of women. So if there is a law which prohibits employment, then it is subsiding the right given under the Equal Remuneration Act. But you know, we have the techno parks, we have a number of shops working even at till 10. Even Lulu, you know, it's working till 11, right? So there are so many women employees, how it's possible for them to engage women after that also? It's true that the changes has happened after the enactment of this equal remuneration. So many amendments have happened. Even with the code, amendments have happened. Yes, changes have happened. But how is it possible? It's possible for the government through order, even exempt. So it's possible for the government to exempt certain establishment from establishment so that they could engage women during this time, even up to 10. That is possible. Again, there is an amendment made. And that amendment is the aftermath of the decision. That decision is quoted here. Teresa Josephine versus State of Kerala. Many a times you find that legislation lags behind. Legislation fails to take note of the requirement of the society promptly. So the agreed people approach the High Court, Supreme Court, and the judgment, based on the judgment, they are in a position to get the remedy. And subsequently, based on the same judgment, others also claim for the same remedy. That is what we could see in the case of Teresa Josephine versus State of Kerala. Even, you know, the Sexual Harassment Act 2013, it is the result of the Vishaga Guidelines. Vishaga Guidelines 96-97, the act came out in 2013, but still we stretch back to the Vishaga decision. So here, this is a judgment delivered by Justice Anu Shivaraman, ma'am. She's now in Supreme Court. She was one of the judges at that point of time in High Court. So she was saying that, basically that section 66(1)(b), which is incorporated at that point of time, long back, Factories Act 1948. At that point of time, the number of women workforce was very less. And even if very less. So even if something happens within the factory, there is no one else to help her. Then, that is one point. Next thing is that it is a protective provision. Equally, we know that even as far as law students or any other students are concerned, hostel timing, they say that it's a curfew timing. So they argue that, okay, based on the protective nature, security concepts, please don't restrict our liberty right. But the court, just through Justice Anu Shivaraman, saying that let the protective provision be there in the statute. Don't try to challenge the protective provision. If you take away the protective provision, then any woman who wants to really invoke that protective provision won't be in a position to invoke it, because many women are even not in a position to engage in night shifts. Is it not true? They can't engage in night shifts because of so many factors, not even familial obligation, but maybe so many factors. So for them, it remains as a protective provision. Don't challenge the protective provision. Instead, what you can do is that I'll require the government to issue an order whereby subject to framing of safety conditions plus consent of the women employed. Consent to what extent? As a women employee, I have to say that I have no objection in engaging in the establishment between a period from 7 p.m. till 6 a.m. If I am ready, but that should not be based on a compulsion. If consent is ready, then sufficient safety conditions are provided in the establishment, security staff. Then if it is, say for example, by 12 next day, is the midnight is the end of the shift, she should be dropped to her home in a cab provided by the employer. And again, you can assume maybe the driver is a lady. Again, lady driver's security need to be assured because she is also employed by the employer. Again, if the cab driver can be a male also, from that part also harassment can occur. So it is said that another person should accompany. Again, you can think of who is that another person. Is it a lady or an employee? This is what, because as one of the students was asking the honorable judge, Has judiciary failed, or is it not judiciary not strong enough to deal with all these things? Basically, internalization aspect is one thing very much lacking in our society. Internalization means we have to incorporate something in us, then act. Okay, coming back. So respect. So again, Elizabeth ma'am was talking about, he was raising some points so that we could challenge the neutrality, change to make the women-specific legislation neutral. Why are we arguing for making women-specific legislation neutral? Women are deprived section, marginalized section. It will remain as that. But we are 14, Article 14, Article 15.3 permit the legislature, the parliament, to make law protecting them, women only. So rather than requiring the government to make these women-specific legislation gender neutral, why can't they make exclusive legislation for the deprived? That is also permitted under section Article 14, 15.3, 16. So these are some points to challenge, those who are urging for making women-specific legislation gender neutral. There is no point in that. Okay, next is relating to the same element I was discussing, discriminatory provision. Sanuja versus Kerala State Beverages Corporation Limited, 2016, again by Justice Anu Shivaraman ma'am. Here there was a government order, as you know, places where liquors are being served and consumed. Generally, we have a belief that it is not a safe place for women to work. And there is a, towards the next decision, Dhaniyamal versus State of Kerala, there is an interesting thing. Why the government passed an order restricting or prohibiting employment of women in such places where liquors are being sold, or even including a condition that no women shall be employed. Then only you will be issued with a license to carry on this trade. They were saying that government was receiving a number of complaints saying that in these places women are being employed and they are subjected to harassment. So that again was declared unconstitutional. That order was also nullified. Again, there is a specific instruction given to Kerala PSC. That was an appointment made by the Public Service Commission. So specific instruction was given to Kerala PSC to issue advice memo to the lady candidate so that she could be employed in the sector. Then the first judicial decision that gives a standing to all these discriminatory provisions under the Factories Act, Kerala Shops and Commercial Establishment Act, which restricts employment of women during the peak, during this time, as I mentioned, 7 p.m. and 6 a.m., Zanuj Garg and others versus Hotel Association of India, 2008 decision. There the court has categorically mentioned that any such restriction amounts to violation of right to individual autonomy, Article 21, dignity, right to self-determination, decide for one's same thing, right to personal choice, and there shall not be any restriction on right to choose a vocation. If I decide that I can, because it is I want to choose a livelihood. There's no other vocation. I'm not getting any other job. So this is one of the opportunities I got. So I should find, somehow I should be absorbed in that. So I'm ready to choose that vocation. So I should be employed in that place where the liquor is served. Okay, but the employer has to make provision for the safety of the employee. Otherwise, it amounts to complete prohibition. Even Article 19(1)(g) is there. Freedom to carry on trade, profession, occupation. That is a Maulika Avakashan. So on the same line, we have the 1995 decision. This is from Supreme Court, other from the Kerala High Court. A number of decisions are delivered by Justice Anu Shivaraman with respect to the work shifts. Next. Okay, now under the labor codes, occupational safety health condition code, this decision has been reflected. Can I move it now? This one, right? Okay. So this is the position now. Subject to safety conditions, subject to the consent of the women that I am willing to work during this shift. Yeah, it's working. Now moving to, so jumping from equal remuneration to the sexual harassment, I connected with this act earlier also. So basically, the term sexual harassment, I think you know, even verbal abuse is sufficient enough to bring it under, not mere touch or a sexual, showing pornography, that everything comes. Verbal abuse also amounts to. Again, what amounts to sexual harassment? That is for the women to specify. If just a staring, means not just a staring, looking at the women, a closer observation, that itself, if it creates a discomfort, that can tantamount to sexual harassment. So from the perspective of women, even I believe one of the resource person was talking about sexualizing. Again, what is the effect on the women? That based on that you could. Again, one of the arguments, the key arguments leveled against the statute is that misuse of the statute. Misuse of the statute cannot be raised as an argument against non-implementation of a protective legislation. Under this statute, there is one provision which says that if a misuse is found, then whatever punishment which could be imposed on the perpetrator or the respondent, same punishment could be imposed on the so-called the one who has filed the complaint, that is the aggrieved women. So misuse need not be raised as a allegation for, means as a ground for negating or non-implementation of the statute or challenging the statute as unconstitutional. Then there is element of quid pro quo. You need not find in every case quid pro quo, but that doesn't mean that in the absence of quid pro quo means if you do this, if you do a sexual favor for me, I'll sign for you in the promotion paper. You can't find that in every case. Even otherwise also, you could bring it under the ambit of sexual harassment. Whatever you feel discomfort, which is affecting, which has a sexual nature, that could be brought under, because it is your right. You are in the workplace environment, so you should have a safety atmosphere in the workplace so that you could carry on your right, basically right to livelihood, right to carry on your trade, profession, occupation, and it is the responsibility of the employer. Then, crucial points here, aggrieved women. This is, one of the challenges, as I was saying, misuse is there, another challenge. Aggrieved women, that term is clear, only a woman who is abused can file a, only a woman is an aggrieved woman, yes. Who can file a complaint? Aggrieved women can definitely file a complaint, but the complainant can be another person also. Why? Suppose a woman who is not in a position to file a complaint, maybe a disabled, specially abled person, or no, there are some factors which prevents her from filing the complaint. Some other person, not some other person, a relative, or in case of a specially able person, special educator, there are some lists provided under the rules. They can file complaint. In that case, complainant will be another person. So there is nothing wrong in saying that complainant could be any person, but the aggrieved is a woman only. And if you want to stretch it to the extent of including even transgenders or a male person, that is something unconstitutional. Why? The POSH Act is implemented, so POSH Act is enacted solely. The title, we say POSH, but it is, the title is Sexual Harassment of Women at Workplace. So in the term women can be infused, men, transgenders, or for them, for transgender disadvantaged section, marginalized section, next separate legislation could be enacted. And 16.3 does not protect men, for men is separate legislation. That is the same thing we hear with respect to the PWDVR, Protection of Women from Domestic Violence Act. So aggrieved women only. Then employee, another point. And includes employee, whoever engaged by the employer, contract, everything. And includes a co-worker, a contract worker, probationer, trainee, apprentice, or called by any such other name. See, under the labor legislation, an apprentice is not an employee. But for the POSH purview, apprentice is also an employee. If a woman is appointed as being engaged as an apprentice, if you say that apprentice is not an employee, so women apprentice cannot claim protection under the POSH Act, there comes to the end. It is not like that. For some purposes, apprentice is also considered as an employee. So a women apprentice can also claim protection. Then the highlighted one, called by any such other name. Because for UGC governed educational institutions like colleges, universities, which act applies? POSH or the UGC? I'm taking from the purview of the employees only. Which one applies? If it is an educational institution, employees are there, teachers are there, administrative staff are there. Which act applies? UGC. There is UGC regulation 2015. But if it is for schools, it is not UGC regulation, but the POSH Act. Again, another classification. There are some universities like NITs. These are institutions of national importance. For them, the UGC Act does not apply. For them also, what applies? the post act applies. So what I intend to say is that students are not covered here. Girl students are not covered here. But through judicial decisions, it is inferred that for students, for girl students, it is their workplace. They are majority of in a day, substantial hours they are spending in the school. So that they could be considered as a workplace, but they are not strictly speaking employees. So, but this decision is the basis for claiming that students in schools and those educational institutions not covered under the UGC regulation can claim protection under the 2013 Act. So that is also one of the lacuna in the provision. I'm trying to pinpoint certain lacunas also because my topic is optimizing labor legislation. What is the lacuna in the law? Then trying to make it more stronger to pick the loopholes and fill it up. Then respondent, I was saying, respondent, who can be a respondent? Of course, a male. Can a woman be a respondent? Yes. Women could also be a respondent. There is a Calcutta High Court decision. So it says that women, same sex, but women against another woman, that a woman could also be a respondent. Respondent person against whom the aggrieved woman has made a complaint. Women could be there. Then, recently in the 2025 cited, it's not 2026, right? Just 1 month back only. So Hali Malik versus Union of India. This is one such decision which made it clear. If a woman employee faces harassment or is harassed by a third party harassment is not a term which you could find under the Post Act. Third party harassment can take place in education institution. See, it talks about harassment between employees. Third party harassment is newly introduced. That means, say for example, in an education institution not coming under the purview of the Post Act. Coming under the purview of Post Act. If you are talking about employees, say there is a visitor from outside and he has abused a women employee in the institution. If you go strictly by the Post Act, no remedy. But Post Act aims at conferring instantaneous remedy. So this decision says that, okay, third party harassment could also be addressed through the Post Act. But again, there is a lacuna which says that third party harassment, the third party should be employed somewhere. But even without the decision, when you construe the provision, it is implied that it is possible if the third party who harasser is employed in any other establishment, either in the establishment of the third party or in the establishment where the aggrieved woman is working, that IC could take up jurisdiction could be exercised by any of the ICs. But the issue remains with respect to a third party who is not employed. But this decision has not addressed that aspect, only employed. There is another, so what could be done? Say compensation, monetary compensation is one of the remedies here. That is necessary, is it not? Because the lady might have undergone mental trauma, she might have sought medical assistance, so many expenditure might have been met out of her pocket, so that needs to be given to her, right? So if he is not employed, how that monetary compensation remedy could be tackled? There is one provision which talks about either from the salary, if an order is passed requiring the respondent or the perpetrator to give this much amount to the aggrieved women, and it is found that the perpetrator is absenting from work, or he has been absenting from work a number of months. For namesake, he is employed. So there is no salary due. So how could he be proceeded against for getting the monetary compensation? So that, okay, as if it is arrears of land revenue, the collector can proceed. But that is not extended with respect to the third party harassment. So that is again one of the lacuna. So if we are harassed by a visitor, if he is employee, yes, fine. Employee of another institution. If he is not employed anywhere, even the remedy, last remedy I said, as arrears of land recovering, as if it is arrears of land revenue cannot be invoked. That I mentioned, same-sex respondent I mentioned. Now, online complaints, that is another thing. Online complaints, after COVID, we have been receiving complaints through emails also. But that has been challenged by that is often challenged by response saying that complaint under the Sexual Harassment Act says that it should be in writing, everything in detail, and 6 copies should be given. If it is online, if the email is accepted as a complaint by the IC's procedure will be challenged. but we go ahead with the complaints. But we need to equally give explanation for accepting it because the Act has not addressed it. But there is another initiative in the form of She-Box. She-Box, electronic box, where it's a centralized scheme where the central government has opened up a one-stop center like that, where every organization is vested with the duty to create IC. So every organization has to register under the She-Box, and they have to specify the nodal officer, and the complainants can directly file the complaints through that. That is another method. But I would say that specific provisions enabling the aggrieved women to file online complaints must also be there. Because many of you youngsters go for emails only, right, rather than writing. Do you have the habit of writing notes in class? Even not going through your notes, written notes not there. Going through the textbooks during examination, no, everyone go with the iPads like that only. That is my experience with my students. Okay, organized, unorganized, I'll come to that at the end. Local committee, again, there is a local committee. IC is within the organization. Local committee is for domestic workers. Domestic workers, domestic workers who don't have any single employer, but so many employers. So for that, there must be a nodal officer. We are not sure how many nodal officers are appointed to deal with that. It is the responsibility of the district officer to create local complaints committee, local committee, and appoint nodal officers. So there is some lacunae with respect to the appointment of nodal officer. Equally with respect to the dowry prohibition officer. With the series of incidents we have noticed in Kerala, we have the benefit of so many dowry prohibition officers being appointed. That is an issue. Then suppose an agreed employee who has faced the sexual harassment from the employer, to whom she approaches? Because the employer constitutes the IC. Whom she approaches? Not approach here. Agreed women. Employer has harassed the women. Whom she approaches? IC? IC is created by the employer. LC. But even there is an issue. It says that it is not a general clause saying that LC applies to all organizations where IC is not created. Instead it says LC applies to all organizations where the number of workers is less than 10. But in my institution, the number of workers is more, but there is no IC. Again a loophole. Then I'll take 5 more minutes. This is the procedure for filing complaint. Again, one more thing. We often use the term ICC. LCC, it is not ICC, it is internal committee, locals committee. Because don't think that IC will work, internal complaints committee work only when a complaint is received. It should be a running, it should be always there. Even without complaint, it should work. That is the 2016 amendment. General Amendment Act introduced that change, not the Posh Amendment Act. I'll finish it soon. Move. These are the remedies. One more thing. 3 months. If a woman is sexually harassed, she may not be in a position to join the office soon after the day. Think of it. So 3 months leave could be given in addition to all statutory leave. I don't think all statutory leaves are paid leaves. Unpaid leaves are also there. So that should be made. I believe so. Unpaid statutory leave are also there. So it should be made paid, 3 months paid. For argument's sake, you may say that it's 3 months paid leave only, but statute is silent with respect to the paid side. Oof, sorry. It's taking time to move the slide. Now, this is the last point, gender neutral. Do you want women-specific legislation to make it gender neutral, at least the women? Do you want to make it as gender neutral? The purpose is gone. In Binu Tanta and another versus High Court of Delhi, recent 2023 decision, very relevant decision, where the petition has been filed to make the Posh Act gender neutral. The very objective is gone, protection of sexual harassment of women at workplace. So the court rejected the petition. Against that decision, even the judge was criticized, saying that he's not taking into account the transgender person, the other marginalized section. For them, exclusive legislation could be made. That is also there under the statute. Special provision 16.3. So reiterated objectives of the act and said that inclusion cannot be possible. LGBTQIA, that was the claim to include that. Not possible. And prevention of the misuse aspect I mentioned in the beginning. Let's move into the end. Yes, you have heard of Advocate Shobha ma'am saying, I think in the comparing portion, We the Women of India. She is the founder of We the Women of India. In fact, they filed a case in the year 2023 urging the non-implementation aspect, that there is failure on the part of the government as well as the various organizations to constitute IC and implement the statutory protections. So the court has passed directions to the central government. Even repeated directions were also given. So in that, there was a reference to the Mission Shakti scheme. That was a scheme introduced earlier, but it was not so effective. So they asked for creation of a one-stop machine whereby all agreed women, irrespective of the statute under which they come under, say PWD Act is there, we have the POSH Act, so irrespective of the statute they are coming in, they could file their grievances and get it redressed. Then Aureliana Fernandez was the state of Goa, and initiatives for English are two other legislations which typically concentrates on the sexual harassment of women at workplace. Just see, it is near to the end of 2024. They have issued, the judgment says that there is so much of lapse from the part of the organization to constitute IC and reviewing the functioning of the IC. So in that context only, they have revived. It is only, I think, 2017, they have initially launched the She Box. But in 2024, soon after the decision, they asked for revival of the She Box, make it active and enabling the abuse, enabling the, the aggrieved to make use of this provision. So that is openly accessible, right? I think this is the end. Maternity benefit act. Okay, now move on to maternity benefit is applicable to unorganized women workers. You will ask me who are unorganized women workers. A daily wage worker, a construction worker, maternity benefit applies or not? There is Plantation Labour Act, which talks about maternity benefit to the plantation labourers. There is Mines that also talks about maternity. There is ESI Act, Employee State Insurance Act, which talks about Section 51, talks about maternity benefit, provided the Maternity Benefit Act is not applicable. So separate legislations are there. So, and all these are all labor legislations. They fix a cap by saying that establishments where 10 or more employees or 20 or more employees. So there are people working in establishments where less than 10 are employed, for whom they are also employees. So what is the mechanism for them? There is a central government initiative. So it's true that 2017 Amendment Act has taken care of the contract workers. True. Even for that aspect, we have a judgment from Justice Anu Shivaraman ma'am, that in that case, the court was observing about, yes, Mini versus LIC, Rakhi versus State of Kerala. That is, Rakhi versus State of Kerala is a decision by Justice Anu Shivaraman ma'am, where she was saying that even a contract women laborer engaged for a 1-year contract, she is entitled to claim maternity benefit. That initially, she was given only maternity leave for 3 months as per the government order. She is not a regular employee, so based on the government order, she is entitled to get 3 months. Anyway, during that period, she can't be there at the establishment. 3 months is given. But in that particular case, it is a situation where her employment contract was renewed. It has been renewed for a number of years, more than 6-7 years. The court said that she should be treated as par with the employee, not for the purpose of giving all the benefits regular employee is receiving, but for maternity benefit, 6 months. Another case, if the contract term is for 1 year, say 1 year, but if maternity leave is given, it exceeds the contract term. Should the women be given maternity benefit? Usually we say that, why should we bring the employer in trouble? Here the court said that. Kavita Yadav, that is a Supreme Court decision, the court said that she should be granted maternity benefit. This is the contract worker, the depressed class. Yes, this is a bill pending This is so many, this is a bill, 2023 bill, so many positive features like maternity benefit fund. If the woman is working in an unorganized sector, who will provide for the maternity monetary fund, monetary benefit? So it talks about the responsibility of the government to create a maternity benefit fund. There, contribution on the part of the government, contribution in the form of CSR, corporate social responsibility. That is one of the important source of this fund, maternity benefit fund. That is available for unorganized. You may be, those who are basically LLB students, they may be wondering why I'm talking about unorganized separately, because the new labor codes, it is said that they are applicable to both organized and unorganized. When you go through the provisions, you could see only the chapters, some chapters are applicable to unorganized, not the entire thing. Okay. It also talks about the board, welfare board, maternity benefit, maternity benefit fund, I said. Now moving to the last portion. I believe it is the last portion. Only when something is granted through a statute, we call it as a statutory right. And that statutory right is not something an enabling provision, it is a right per se. It is not a charity. But when it takes the shape of a scheme-based protection, it is not as par with or not equal to the statutory right. It depends on the fund availability. I refer to the directive principles of state policy, depending upon the economic capacity. So what we prefer is, at least in the life cycle approach, adopt the life cycle approach plus a right-based social security approach, so that laborers, who is not at all considered as a commodity now, but even in some occasions or in some establishment, because of the color of privatization, liberalization, globalization, you could see they are being treated as commodity, hire and fire, everything. But basically in that context, I would say they should not be treated as a commodity, especially considering the women employees, they are sacrificing their so many rights. They are sacrificing their responsibilities. I'm not going for a division of labor between men and women, who should take care of their children, not going for that. I'm talking the purview of as a woman, I'm talking from the purview of an individual personhood, not from the point of a gender specific thing. So there should be a balance between right to motherhood and right to employment. Yes, motherhood is different from the fatherhood or the concept like that. Right to motherhood and right to employment. That is something to be balanced. Whatever be the challenges from the point of gender perspective. With this I conclude. Thank you.
Thank you, ma'am, for this insightful presentation on the existing legal frameworks and strategies for women at work. Do we have any questions? Can we have any questions that you can directly ask ma'am regarding the legal aspects in workplace you might have encountered or heard about, any instances which you would need to check personally? You can do that now. ഈ വിഷയത്തെക്കുറിച്ച് നിങ്ങൾക്ക് എന്തെങ്കിലും ചോദിക്കാനുണ്ടെങ്കിൽ ചോദിക്കാൻ പറ്റിയ ഒരു അവസരമാണിത്.
Hello. Ma'am, thank you for your wonderful speech. Ma'am, as the director of NUALS and all, I just need to know your perspective on how well these information should be included in our curriculum, especially when these things are only taught at a graduate level where people engage in a law, a syllabus like a law or something like that. Other than that, should it be included in the curriculum of a school or other graduation level where people will be more empowered and they have a better position to understand these things in the future?
Apart from the LLB program?
Yes.
Okay, LLB program. In schools, there is a special branch called legal studies. In many of the schools, they have a special stream as such, just like the maths, social science, biomaths. They have a legal studies department also. So that is taken care of. It is for the schools to choose it. It is taken care of.
Do you think there is a void of information there, or is it an application? Is it a problem of the implementation?
It is for the schools to implement it. There is possibility. And there is a program introduced from the part of the central government itself. Even our law students, we were worried about employments. because law was not such a even welcoming as well as not an attractive profession. So we were worried about getting employed. But nowadays, apart from the corporate field, even school, even when this particular step was initiated from the central government, even the CBSE, we were so happy because at least we will be employed in schools because they have a different department for legal studies and you will be employed. Even, so that is there. As part of the scheme, it is there. Because the schools, if schools can take initiative under that, it is there, already there.
Do you think there is an urban and a rural disparity in this?
I think in rural, there are many initiatives being taken. Rural, because many people are even as part of the legal aid program, that is not based on a regular, not on a regular basis, but as part of the legal aid program, they are also inviting even universities, resource person from the universities, colleges to conduct awareness classes there. As part of the curriculum, it is already there. That is why I said our law graduates are partly engaged in taking classes in schools and even conducting, even engaged in research. Okay. Livelihood, right to livelihood plus education. Thank you.
Thank you for the question, and thank you, ma'am, for the answering. Do we have any more questions? Do we have any more questions? No. Okay. May I please call upon Ms. Anita Deepthi, the District Women and Child Development Officer, Idukki, to kindly present a memento and a word of gratitude.
Legislation for empowering women at work reviews and strategies എന്ന വിഷയമായിരുന്നു മാഡത്തിന് ക്ലാസ് എടുക്കാൻ ഉണ്ടായിരുന്നത്. ഡോക്ടർ നമ്മുടെ ഭരണഘടനാ ശില്പിയായ ഡോക്ടർ അംബേദ്കർ തുടങ്ങി ഭരണഘടന അനുശാസിക്കുന്ന വിവിധ തൊഴിൽ നിയമങ്ങളായ ഈക്വൽ റെമുനറേഷൻ, മെറ്റേണിറ്റി ബെനിഫിറ്റ് ആക്ട്, ഫാക്ടറീസ് ആൻഡ് ബോയിലേഴ്സ്, ഷോപ്സ് ആൻഡ് കമേഴ്സ്യൽ എസ്റ്റാബ്ലിഷ്മെൻറ്റ് ആക്ട്, പോഷ് ആക്ട്, ഇതേക്കുറിച്ച് വളരെ വിശദമായി ഇവിടെ അവതരിപ്പിച്ചു. കാര്യങ്ങൾ നിയമങ്ങളെക്കുറിച്ചും അത് കഴിഞ്ഞുണ്ടായിട്ടുള്ള എല്ലാ കാര്യങ്ങളെക്കുറിച്ചും വളരെ വിശദമായി തന്നെ ഇവിടെ അവതരിപ്പിച്ച നാഷണൽ യൂണിവേഴ്സിറ്റി ഓഫ് അഡ്വാൻസ്ഡ് ലീഗൽ സ്റ്റഡീസിലെ ഡയറക്ടറായ ഡോക്ടർ ഗീത മാമിന് വകുപ്പിൻ്റെ പേരിൽ വളരെ അധികം ഹൃദയം നിറഞ്ഞ നന്ദി രേഖപ്പെടുത്തിക്കൊള്ളുന്നു.
Now we are moving on to the concluding session of the day as well as the conclave. It's my privilege to introduce and welcome Professor Vani Kesari A, who is a distinguished academic and legal scholar with extensive experience in constitutional law and human rights. She serves as professor and honorary director of the Professor N.R. Madhava Menon Interdisciplinary Center for Research Ethics and Protocols, and as Dean, Faculty of Law. She is also the former director of the School of Legal Studies at Cochin University of Science and Technology. Ma'am holds a PhD in law from CUSAT and an LLM in Constitutional and Administrative Law from the University of Kerala, where she was a rank holder. With over 2 decades of teaching experience and earlier legal practice at the High Court of Kerala, she has shaped generations of legal minds. Her academic expertise spans constitutional law, human rights law, humanitarian law, bioethics, and health law. Today, Professor Vani Kesari would be talking on a very interesting topic, women's reproductive rights, gaps in existing legislation. Please join me in welcoming ma'am. Welcome, ma'am. Over to you.
A warm good evening to one and all. Esteemed chair of the session and participants of the seminar. പൊതുവെ നമ്മൾ സെമിനാറുകൾ സ്ത്രീകളെക്കുറിച്ച് സംഘടിപ്പിക്കുമ്പോൾ സ്ത്രീകൾ തന്നെയാണ് സംസാരിക്കുന്നത്, വേദിയിലും സദസ്സിലുമെല്ലാം. ഇന്നും ഞാൻ കാണുന്നത് കൂടുതലും സ്ത്രീകൾ തന്നെയാണ്. This is where the change in mindset is required. Because unless and until whatever legislations which we bring in, if there is no change in mindset, everything goes. So that's the first statement which I would like to make. I know that all of you are tired after lunch, but I would just give you a glimpse of certain legislations or certain positions in law worth knowing. നമ്മൾ അറിഞ്ഞിരിക്കേണ്ട ചില കാര്യങ്ങൾ. നമ്മൾ പലപ്പോഴും നിയമം പഠിച്ചും പഠിപ്പിക്കുന്നവർ പോലും അത് ശ്രദ്ധിക്കാതെ പോകുന്ന ചില കാര്യങ്ങൾ. അത് മാത്രമേ ഞാൻ പറയുള്ളൂ, വലുതായിട്ട് ബോറടിപ്പിക്കാൻ പ്ലാനില്ല. സോ റീപ്രൊഡക്റ്റീവ് റൈറ്റ്സ് ഓഫ് വുമൻ, ഗ്യാപ്സ് ഇൻ എക്സിസ്റ്റിംഗ് ലെജിസ്ലേഷൻ, ഇതാണ് എനിക്ക് തന്നേക്കുന്ന ഒരു ഏരിയ. ഇങ്ങോട്ടാണ് കാണിക്കാൻ. ഓക്കെ ലാപ്പ്. See, this is a group saying that my body, my choice. I am pro-choice because abortion is never an easy choice. Sometimes the right choice, always a woman's choice. എപ്പോഴും നമ്മുടെ ശരീരമാണ്. എല്ലാ മനുഷ്യർക്കും അവരവരുടെ ശരീരം ഇമ്പോർട്ടൻ്റ് ആണ്. അതിനെക്കുറിച്ച് എന്ത് തീരുമാനം എടുക്കുമ്പോഴും നമുക്ക് തന്നെയാണ് എടുക്കാനുള്ള അവകാശമുള്ളത്. ഇത് തന്നെയാണോ നിയമം പറയുന്നതെന്നുള്ളതാണ് ഇന്നത്തെ ഡിസ്കഷൻ. മാറ്റിയാലും മതി, ഞാൻ നെക്സ്റ്റ് എന്ന് പറഞ്ഞോളാം. നെക്സ്റ്റ് സ്ലൈഡ്. ചില കാര്യങ്ങൾ നമ്മൾ മനസ്സിലാക്കിയിരിക്കേണ്ട ചില ബേസിക് ആയിട്ടുള്ള കാര്യങ്ങൾ. ഇപ്പം നമ്മൾ നേരത്തെ കണ്ട സ്ലൈഡിൽ ദിസ് സ്ലോഗൻ ഇസ് ക്വൈറ്റ് ഫെമിലിയർ ടു ഓൾ ഓഫ് us, ബട്ട് ഇറ്റ് ക്യാൻ ബി ഫൗണ്ട് ദാറ്റ് ദിസ് സ്ലോഗൻ വാസ് എ പ്രോഡക്റ്റ് ഓഫ് എൻ അൺനോൺ വുമൺ. ആരോ എവിടെയോ പറഞ്ഞ് ഏതോ ഒരു സ്ത്രീയുടെ വായിൽ നിന്ന് വന്ന ഒരു സാധനമാണ്, ഒരു സെൻറ്റൻസാണ്, ഒരു സ്റ്റേറ്റ്മെൻറ്റാണ്. ആരുടെങ്കിലും മനസ്സിൽ, ഏതെങ്കിലും ഒരു സ്ത്രീയുടെ മനസ്സിലുണ്ടായ ഒരു സ്റ്റേറ്റ്മെൻറ്റാണ്. Or when a woman came forward and asserted that she has got a right to over her body. Thus, the birth of reproductive rights, which became not only a legal or a human right, but is also an area for a society to ponder and discuss. Today's discussion here is based on the primary question as to whether an ordinary woman has a right over her body and the right to decide as to when she has the right to conceive. എപ്പോഴാണ് ഞാൻ കൺസീവ് ചെയ്യേണ്ടതെന്നുള്ളത്, ഏത് സമയത്താണ് ഞാൻ കൺസീവ് ചെയ്യേണ്ടതെന്നുള്ളതും, and what would be the spacing between her children if she has already conceived. Next slide, please. Reproductive rights for women encompasses the fundamental human right to make autonomous decisions about their bodies, sexuality, and reproduction without coercion, discrimination or violence. ഒരു തരത്തിലുള്ള കൊയർഷനും അവളുടെ മേലിൽ വരാൻ പാടില്ല അവളൊരു ഡിസിഷൻ എടുക്കുമ്പം. അതുപോലെ തന്നെ അവളെ മാറ്റി നിർത്താൻ പാടില്ല. അവൾക്ക് ഇപ്പോൾ കുഞ്ഞിനെ വേണ്ട എന്ന് അവളുടെ മനസ്സ് തോന്നുകയാണെങ്കിൽ അവളെ സമൂഹം മാറ്റി നിർത്താൻ പാടില്ല. ആൻഡ് there should be absolutely no violence against her for taking such a decision. So the key rights within the entire gamut of reproductive rights is if and when to have children, accessing contraception, safe abortion services, maternal health care, and protection from forced sterilization or forced marriage. Next slide, please. Let's look into the key aspects of the right. Basically, this right stems from bodily autonomy, the right to decide on, control over one's own body, including the decision to reproduce or abstain from procreation, access to health care, safe abortion access, freedom from coercion, access to education and information necessary to make informed reproductive choice. Next slide. Any discussion on the legislative history of this right should essentially stem from Indian Penal Code. നിങ്ങൾക്കൊക്കെ അറിയാം, ഇന്ത്യൻ പീനൽ കോഡ് എന്ന് പറയുന്നത് ഒരു കൊളോണിയൽ ഇറയിൽ ഉണ്ടാക്കിയ നിയമമാണ്. അതനുസരിച്ച് അത് കുറേ ഡിക്കേറ്റ്സ് ആയിട്ട് ഈവൻ കഴിഞ്ഞ 2023 നമുക്ക് കാണാൻ പറ്റുന്നത് ഭാരതീയ ന്യായ സംഹിത വന്നത്. അതുവരെ നമ്മൾ ഫോളോ ചെയ്തിരുന്ന നിയമം തന്നെയാണ്. ഇന്നും കോടതികൾ ഈ നിയമത്തിനെ നോക്കാറുണ്ട്. BNSൻ്റെ പ്രൊവിഷൻസും ഇതിനെയും കമ്പയർ ചെയ്ത് ഡിസിഷൻസ് വരാറുണ്ട്. അപ്പം സെക്ഷൻ 312 IPC ആണ് ഇന്ന് നമ്മൾ ചർച്ചാ വിഷയം. ഇത് അബോർഷൻ ചെയ്യുന്നത് ഒരു ഒഫൻസായിട്ടാണ് ട്രീറ്റ് ചെയ്യുന്നത്. ഇന്നും അങ്ങനെ തന്നെയാണ്. It is an offense done by a woman and the doctor who performs it is also criminally liable. അപ്പം സ്ത്രീ സമ്മതിച്ച് സ്ത്രീ അബോർട്ട് ചെയ്തിരുന്നാലും എനിക്ക് അബോർട്ട് ചെയ്യണമെങ്കിലും എനിക്കത് ചെയ്യാൻ സ്വയമേ പറ്റില്ല. അങ്ങനെ ഞാൻ ചെയ്താൽ അതൊരു ക്രിമിനൽ ഒഫൻസാണ്. ആൻഡ് യു ഫൈൻഡ് ദാറ്റ് അങ്ങനെ എനിക്ക് വേണ്ടി ചെയ്യാൻ വന്ന ഒരു ഡോക്ടർ ഉണ്ടെങ്കിൽ ആ ഡോക്ടറും ക്രിമിനലി ലയബിൾ ആകും. So therefore, once conceived, it is the responsibility of a woman to bear the child even if she does not want it. അവൾക്ക് വേണ്ടെങ്കിൽ പോലും ആ കുഞ്ഞിനെ അവൾ വളർത്തേണ്ടി വരും. The section did not look into the question of her decision making, her likes, what she decides to continue, or whether she is desirous of taking care and growing up the child. ആ കുഞ്ഞിനെ വളർത്തുന്നത് എങ്ങനെയാണ്, അവളുടെ തീരുമാനങ്ങളിലെ ഒന്നും ഒരു പരിഗണനയും ആ പ്രൊവിഷൻ്റെ കൊടുക്കുന്നേയില്ല. മറിച്ച് ഡോക്ടർ സമ്മതിക്കണം, ഡോക്ടർ പറയണം അവളുടെ ഫിസിക്കൽ കണ്ടീഷന് അവൾക്ക് അബോർഷൻ ചെയ്യണം, അവളുടെ ഫിസിക്കൽ കണ്ടീഷൻ അത്ര മോശം ആണ്, അതുകൊണ്ട് അബോർഷൻ ചെയ്യണം എന്ന് ഡോക്ടർ സർട്ടിഫൈ ചെയ്താൽ മാത്രമേ ഇന്നും അവൾക്ക് അബോർട്ട് ചെയ്യാൻ സാധിക്കുള്ളൂ. നെക്സ്റ്റ് സ്ലൈഡ് പ്ലീസ്. Questions as to her psychological, financial capacity to take care of the child was never given any importance by law. Such questions were never being addressed even by law for decades together. It was in 1971 when the Medical Termination of Pregnancy Act that it was publicized that here came a legislation to empower the woman. 1971 Medical Termination of Pregnancy Act നിലവിൽ വരുന്നു. ഭയങ്കര പബ്ലിസിറ്റിയാണ്, അപാര പബ്ലിസിറ്റിയാണ്. എന്തിനാണ്? വുമൺ എംപവർമെൻ്റ് ആണ് സംഭവം. സ്ത്രീകൾക്ക് ഇനിയും അബോർഷൻ ചെയ്യാം. ശരിക്കും അങ്ങനെയാണോ? നിങ്ങൾ മെഡിക്കൽ ടെർമിനേഷൻ ഓഫ് പ്രഗ്നൻസി ആക്ടിൻ്റെ പ്രൊവിഷൻസ് നോക്കുകയാണെങ്കിൽ നിങ്ങൾക്ക് കാണാൻ പറ്റും സ്ത്രീകൾക്ക് അബോർഷൻ ചെയ്യാനുള്ള റൈറ്റ് ഇപ്പോഴും ഡോക്ടർമാരുടെ കയ്യിലാണ്, ഇപ്പോഴും ജുഡീഷ്യറിയുടെ കയ്യിലാണ്. സ്ത്രീക്ക് ഇപ്പോഴും അബോർട്ട് ചെയ്യണമെങ്കിൽ അവൾക്ക് ഡോക്ടറിൻ്റെ സർട്ടിഫിക്കേഷൻ ഉണ്ടെങ്കിൽ മാത്രമേ അബോർട്ട് ചെയ്യാൻ സാധിക്കുള്ളൂ. നെക്സ്റ്റ് സ്ലൈഡ് പ്ലീസ്. When we trace the social context of 1971, it was in that year India introduced the family planning policy. And that really necessitated the enactment of legislations like Medical Termination of Pregnancy Act. ആ സമയത്ത് ഇന്ത്യ ഫാമിലി പ്ലാനിംഗ് പോളിസി ഇൻട്രൊഡ്യൂസ് ചെയ്യുന്ന സമയമായിരുന്നു. അപ്പം ഫാമിലി പ്ലാനിംഗ് വേണമെങ്കിൽ ഈ മെഡിക്കൽ ടെർമിനേഷൻ ഓഫ് പ്രഗ്നൻസി ആക്ടും നിലവിൽ വന്നേ പറ്റുള്ളൂ. അപ്പം മന്ത്രിസഭ കൂടി ഇരുന്ന് തീരുമാനിച്ചു നമുക്ക് മെഡിക്കൽ ടെർമിനേഷൻ ഓഫ് പ്രഗ്നൻസി ആക്ട് കൊണ്ടുവന്നിട്ട് ഫാമിലി പ്ലാനിങ് അപ്പോൾ അതനുസരിച്ച് മുമ്പോട്ട് പോകുന്നു. അവിടെയും സ്ത്രീ സെക്കൻഡറി പൊസിഷനിലായിരുന്നു. സ്ത്രീകളുടെ റൈറ്റ് ടു അബോർഷൻ ഓർ ബോഡിലി ഓട്ടോണമി വാസ് നെവർ ടേക്കൺ കെയർ ഓഫ്. In the legislative discussion, it was said that at least certain types of abortion needs to be legalized for the family planning program to be successful. no effective consultation with women organizations or representatives was being made. നിങ്ങൾ 1971 ആക്ടിൻ്റെ ആക്ട് നടത്തുന്ന സാഹചര്യം if you look into, you find that absolutely there was no stakeholder discussion with regard to the enactment. സാധാരണ രീതിയിൽ നമ്മളൊരു legislation കൊണ്ടുവരുമ്പം those who are the stakeholders, they are being called forth by the parliamentary committees and they are being given a free say. Otherwise, a public notice is being given. But you find that with regard to the 1971 Act, nothing took place. Immediately, it came into force. Now, from the base of the Act, you find that it was never a right-based enactment, which means that it was never based on women's rights, but it was a byproduct of a policy of a government. So that is the basis of Medical Termination of Pregnancy Act. Now let's look into the important provisions under the Act. Next slide, please. Now, abortion is a qualified right. It is not an absolute right. Section 3 speaks about when abortion is permissible. Up to 12 weeks, you find that one registered medical practitioner is required to give an opinion. Only then a woman can go in for an abortion. Up to 2 weeks, you find that again two registered medical practitioners is required. From 20 to 24 weeks, you find that it has been extended for specific categories of women, including survivors of rape, minors, and in case of fetal abnormalities. ഇതെല്ലാം നമുക്ക് കാണാൻ പറ്റും. എന്താണ് കാണുന്നത്? എല്ലാം കണ്ടീഷണലാണ്. എനിക്ക് വേണ്ട ഒരു കുഞ്ഞിനെ ഇപ്പം ഞാൻ കൺസീവ് ചെയ്തു, പക്ഷെ ഇപ്പം എനിക്ക് വളർത്താൻ പറ്റുന്നില്ല എന്നില്ലെങ്കിൽ എനിക്ക് ആ മാനസിക നില ഇല്ല, ആ സ്ത്രീക്ക് അത് തീരുമാനിക്കാനുള്ള അവകാശം ഇല്ലേ? ലോ അതൊന്നും പറയുന്നില്ല. ലോ ഈസ് നോട്ട് കൺസേൺഡ് അബൌട്ട് ദാറ്റ്. ഗോ ടു ദ മെഡിക്കൽ ബോർഡ്, prove before the medical board that you cannot conceive the fetus, you cannot conceive, so you need the certification of the doctor only, then go for abortion. Thus it is crystal clear that it is not the wishes of the woman upon whom abortion is conducted is being given the power to decide, but upon the doctors. The movement seeking abortion rights for women is a global movement which is visible in UK, US and India being no exception to this. Friends, നമ്മൾ MTP ആക്ടിൻ്റെ ട്രൈസെമസ്റ്റർ റൂൾ എന്ന് പറയും, 21 വീക്സ് റൂൾ. അതിൻ്റെ അകത്ത് സ്ത്രീക്ക് അബോർഷൻ ചെയ്യാം 21 വീക്സ് വരെ ഉള്ളത്. ഈ റൂള് നമ്മൾ US നിന്നാണ് എടുത്തിട്ടുള്ളത്. നമുക്ക് US-ഉം UK-യുടെയും അബോർഷൻ മൂവ്മെൻറ്റ് ജസ്റ്റ് ഒന്ന് കൂടുതൽ പറയുന്നില്ല, നിങ്ങൾ നോക്കിയിട്ടുണ്ടെങ്കിൽ അതിനെ മതത്തിൻ്റെ അടിസ്ഥാനത്തിലാണ് അതിനെ ടൈ ഓവർ ചെയ്തേക്കുന്നത്. നമുക്ക് റോ വേഴ്സസ് വെയ്ഡ് എന്ന് പറഞ്ഞൊരു ഡിസിഷൻ ഉണ്ടായിരുന്നു 70കളിൽ. ആ ഡിസിഷനിൽ പറഞ്ഞത് എന്താണെന്ന് വെച്ചിട്ടുണ്ടെങ്കിൽ ട്രൈ സെമസ്റ്റർ വരെ ഒരു സ്ത്രീക്ക് അവകാശമുണ്ട് അബോർഷന് പോകാനായിട്ട്. അത് കഴിഞ്ഞു ഇതൊരു വലിയൊരു സിവിൽ റൈറ്റ് മൂവ്മെൻറ്റിൻ്റെ ഭാഗമായിട്ട് വന്ന ഒരു ഡിസിഷനാണ്. എന്നാൽ കഴിഞ്ഞ വർഷം ഈ ഡിസിഷനെ റിവേഴ്സ് ചെയ്തു. ഡോബ്സ് വേഴ്സസ് ജാക്സൺ എന്ന് പറഞ്ഞ ഡിസിഷൻ കേസിൽ അതിനകത്ത് പറയുന്നത് സ്ത്രീക്ക് അങ്ങനെ ഒരു അവകാശം ഇല്ല എന്ന് വെച്ചാൽ മതങ്ങൾ പറയുന്നത് എന്താണ്? ഒരു കുഞ്ഞ് ഉദരത്തിൽ വന്നു കഴിഞ്ഞാൽ പിന്നെ അതിനെ നശിപ്പിക്കാൻ പാടില്ല എന്നുള്ളതാണ്. അതുകൊണ്ട് തന്നെ അവൾക്ക് അതിൻ്റെ അവകാശം ഇല്ല. നിങ്ങൾ കേട്ടിട്ടുണ്ടാവും അയർലൻഡിലൊക്കെ നമ്മുടെ മലയാളി സ്ത്രീ തന്നെ മരണപ്പെട്ടത്. അവർക്ക് ഫീറ്റൽ അബ്നോർമാലിറ്റി ഉണ്ടായിരുന്നു, പക്ഷേ ഡോക്ടർ വാസ് നോട്ട് വില്ലിംഗ് ടു പെർഫോം ദ സർജറി ആൻഡ് ഷീ സക്കംഡ് ടു ഡെത്ത്. സോ യു ഫൈൻഡ് ദാറ്റ് ദിസ് ഇസ് എ കേസ് ഓഫ് ഔട്ട്മോസ്റ്റ് ഇമ്പോർട്ടൻസ്, ബട്ട് സ്റ്റിൽ മോസ്റ്റ് ഓഫ് ദ ലീഗൽ സിസ്റ്റംസ് do not give that much importance to it. It is just basically because of the patriarchal mindset which the society at large has. Next slide. Now this was a landmark judgment with regard to the reproductive rights in India. Sujita Srivastava versus Chandigarh administration, which came about in 2009. Here, the Supreme Court of India was dealing with a a petition which was being filed by the Chandigarh administration with regard to a woman with mental retardation where she was raped in a government-run welfare institution in Chandigarh. She was found pregnant for 9 weeks. The state had to seek permission to abort from court on her behalf. In 2009, the court, for the first time stretching the contours of Article 21 of the Constitution, stated that reproductive autonomy includes within the corpus, is being included within the corpus of right to life and personal liberty. നമുക്കറിയാം നമ്മുടെ കോൺസ്റ്റിറ്റ്യൂഷൻ ആണ് സുപ്രീം ലോ ഓഫ് ദ ലാൻഡ് എന്നുള്ളത്. അതിൻ്റെ അകത്ത് ആർട്ടിക്കിൾ 21 ആണ് അതിൻ്റെ ബേസിക് റൈറ്റ് എന്ന് പറയുന്നത്. ആർട്ടിക്കിൾ 21 വേറൊന്നുമല്ല, എല്ലാ മനുഷ്യർക്കും റൈറ്റ് ടു ലൈഫ് ഉണ്ട്, അതുപോലെ തന്നെ പേഴ്സണൽ ലിബർട്ടി ഉണ്ട്. അതിൻ്റെ ഭാഗമായിട്ട് വരുന്നതാണ് ഈ റീപ്രൊഡക്റ്റീവ് അട്ടോണമി. അവരവരുടെ ശരീരത്തിനെ എന്ത് ചെയ്യണം എന്നുള്ളത്, അതാണല്ലോ നമ്മളിപ്പോൾ സർജറിക്ക് പോകുന്നതിന് മുമ്പ് ഇൻഫോംഡ് കൺസെൻറ്റ് കൊടുക്കുന്നത്, നമ്മൾ ഒപ്പിട്ട് കൊടുക്കുന്നത് നമ്മുടെ ശരീരത്തിൽ എന്ത് ചെയ്യാനും നമ്മൾ തയ്യാറാണെന്നുള്ളത്. അതുപോലെ ഏത് മനുഷ്യനും, അത് പുരുഷനും സ്ത്രീയും എന്നുള്ള വ്യത്യാസമില്ല, എല്ലാവർക്കും ആ അവകാശം ഉള്ളതാണെന്ന്. അപ്പം ഈ പർട്ടിക്കുലർ കേസിൽ സുപ്രീം കോടതി പറഞ്ഞു സ്ത്രീക്കും ഈ അവകാശമുണ്ട്. എല്ലാ അവകാശങ്ങളെ പോലെ തന്നെ റീപ്രൊഡക്റ്റീവ് അട്ടോണമി, എപ്പോഴാണ് ഒരു കുഞ്ഞിനെ ആവശ്യമുള്ളത്, എപ്പോഴാണ് ഒരു കുഞ്ഞിനെ ആവശ്യമില്ലാത്ത, കുഞ്ഞിനെ വേണ്ടെന്ന് തോന്നുകയാണ് എന്ന് തോന്നിയാൽ ആ സ്ത്രീക്ക് ആ അവകാശം കൊടുക്കണം. എന്ന് വെച്ചാൽ 9 മാസം ആ സ്ത്രീയാണ് ആ കുഞ്ഞിനെ അവനവൻ്റെ ശരീരത്തിൽ ചുമക്കേണ്ടതും അതുപോലെ തന്നെ ജനിച്ചു വന്നാൽ ആ കുഞ്ഞിനെ നോക്കേണ്ട ചുമതലയും ഉത്തരവാദിത്വവും ആ സ്ത്രീക്ക് തന്നെ ഉള്ളതാണ്. ലെറ്റ്സ് ഗിവ് സ്പേസ് ടു ദ ചൈൽഡ്, സ്പേസ് ടു ദറ്റ് പെർട്ടിക്കുലർ വുമൺ. അങ്ങനെ പറഞ്ഞുകൊണ്ട് ആദ്യമായിട്ട് ഇന്ത്യയുടെ ചരിത്രത്തിൽ നിങ്ങൾ കാണണം 2009 ആണ് ഇങ്ങനെ ഒരു ഡിസിഷൻ വരുന്നത്. The court overruled the decision of the High Court, which ruled in favor of the termination based on compelling state interest in protecting the interest of unborn child. സ്റ്റേറ്റ് പറഞ്ഞു നമ്മൾ നോക്കിക്കോളാം, നിങ്ങൾ മെൻ്റലി റിട്ടാർഡ് കുട്ടിയാണെങ്കിലും നമ്മൾ നോക്കിക്കോളാം, പക്ഷെ നമുക്ക് പേടിയുണ്ട് ഈ കുട്ടിയെ എങ്ങനെ ഞങ്ങൾ വളർത്തിക്കൊണ്ടുവരും എന്നുള്ള രീതിയിൽ ഹൈക്കോടതിയുടെ മുമ്പ് പറഞ്ഞു. അപ്പോൾ ഹൈക്കോടതി പറഞ്ഞു എന്നാൽ പിന്നെ നിങ്ങൾക്കൊരു ഭയം ഉണ്ടെങ്കിൽ നമുക്ക് ആ കുഞ്ഞിനെ വേണ്ടെന്ന് വയ്ക്കാം എന്നുള്ള രീതി വന്നു. അതിനെയാണ് സുപ്രീം കോടതി വേണ്ടെന്ന് പറഞ്ഞിട്ട് പറഞ്ഞു ആ മെൻ്റലി റിട്ടാർഡഡ് കുട്ടി എന്താണ് പറയണതെന്ന് നമുക്ക് കേൾക്കാം. ആ പെൺകുട്ടി പറഞ്ഞു എനിക്ക് ആ കുഞ്ഞിനെ വേണം, എനിക്ക് ആ കുഞ്ഞിനെ വേണം എന്ന് പറഞ്ഞു. അപ്പോൾ കോടതി പറഞ്ഞു ആ കുട്ടിക്ക് ആ കുഞ്ഞിനെ വേണമെങ്കിൽ അത് ജനിക്കുക തന്നെ വേണം, ആ കുട്ടിയുടെ സ്വാതന്ത്ര്യമാണ് നമ്മൾ നോക്കേണ്ടതെന്ന് പറഞ്ഞു. ഇതാണ് സുജിത ശ്രീവസ്തവയുടെ ഡിസിഷൻ. അടുത്തയിലേക്ക് പോകാം. നെക്സ്റ്റ് സ്ലൈഡ് പ്ലീസ്. This is again a landmark decision called as Devika Bishwas versus Union of India. In 2012, as many as 53 women underwent a sterilization procedure in a camp in highly unsanitary conditions in Bihar. ഞാനൊരു ഇൻസ്റ്റൻസും കൂടെ പറയുന്നുണ്ട്, അതിൻ്റെ കണക്റ്റഡ് ആയിട്ടുള്ള കേസാണിത്. അപ്പം 53 സ്ത്രീകൾ സ്റ്റെറിലൈസേഷൻ പ്രോസസ്സിൽ ബീഹാറിൽ വെച്ച് നടന്ന ഒരു ക്യാമ്പിൽ അവർ പങ്കെടുത്തു. അത് ഭയങ്കര എന്താ പറയുന്നത്, ആ പ്രൊസീജിയർ നടന്ന സ്ഥലം എന്ന് പറഞ്ഞിട്ടുണ്ടെങ്കിൽ ഒരിക്കലും ഒരു സ്റ്റെറിലൈസ്ഡ് പ്രൊസീജിയർ ആയിട്ടുള്ള ഒരു സന്ദർഭമല്ല അത് അവിടെ നടന്നത്. യു ഫൈൻഡ് ദറ്റ് ഒരു സ്കൂളിലാണ് നടന്നത്, ഒരു ഹോസ്പിറ്റലിൽ, ഒരു സർക്കാർ ഹോസ്പിറ്റലിൽ പോലും അല്ല ആ സ്റ്റെറിലൈസേഷൻ പ്രോസസ്സ് നടന്നത്. ആൻഡ് ദേവിക ബിസ്വാസ് എന്ന് പറയുന്ന സ്ത്രീ, അവരെ ഒരു ഹ്യൂമൻ റൈറ്റ്സ് ആക്ടിവിസ്റ്റ് ആയിരുന്നു. ഷീ ബ്രോട്ട് ഔട്ട് ദ അറ്റൻഷൻ ഓഫ് ദ കോർട്ട് ഇൻ ദിസ് with regard to absence of pre-operative test on the women. They were not given a counseling before the sterilization process. ഇതെല്ലാം കാണിച്ചുകൊണ്ട് അവരൊരു പബ്ലിക് ഇൻട്രസ്റ്റ് ലിറ്റിഗേഷൻ ആണ് ഫയൽ ചെയ്തത്. ആൻഡ് ദ സുപ്രീം കോർട്ട് സെഡ് ദാറ്റ് ദിസ് ഇസ് ആൻ ഇൻട്രൂഷൻ ഓൺ, നെക്സ്റ്റ് സ്ലൈഡ് പ്ലീസ്. This is an intrusion on the right to reproductive right of a woman. The right to decide, again the court said that the right to decide when to conceive and is based on the right of the woman, and therefore sterilization implemented even through a government policy cannot intrude on a woman's right to decide the thing. 2016 നമുക്ക് കാണാൻ പറ്റും ബോംബെ ഹൈക്കോർട്ട് in High Court on its own motion versus State of Maharashtra held that prisoners also have the right to choose to end an unwanted pregnancy എന്നുള്ളത്. And if it is affecting the physical as well as the mental health of the prisoner, she also has the right to terminate her pregnancy എന്നുള്ളത്. Next slide please. This is again another decision, Murugan Nayakar versus Union of India. ഇതിൽ 32 ആഴ്ച കഴിഞ്ഞ് ഒരു പ്രഗ്നൻസി കഴിഞ്ഞ് ഒരു റേപ്പ് വിക്ടിം, ഒരു 13 വയസ്സുള്ള ഒരു റേപ്പ് വിക്ടിമിൻ്റെ പെറ്റീഷനായിരുന്നു കോടതിയുടെ മുമ്പ്. കോടതി termination allow ചെയ്തു. And considering the age of the petitioner, the trauma she has suffered because of the sexual abuse and the agony she is going through at present, and above all the report of the medical board constituted by this court, കോടതി പറഞ്ഞു, we think it is appropriate that termination of pregnancy should be allowed. Next slide. Again in 2011, the Punjab and the Haryana High Court in this particular case held that under section 3 subclause 4B of the Termination of Pregnancy Act, only the consent of the pregnant woman is required for abortion and not the husband's. ആരാണോ ടെർമിനേറ്റ് ചെയ്യുന്നത് അവരുടെ പെർമിഷൻ മാത്രം മതി, ഭർത്താവിൻ്റെ പെർമിഷൻ ആവശ്യമില്ല ഒരു ഭാര്യയ്ക്ക് pregnancy terminate ചെയ്യാനായിട്ടെന്നുണ്ട്. The court ruled that a husband cannot compel his wife to give birth, protecting the woman's bodily autonomy. അടുത്തത് KS Puttaswamy versus Union of India 2018. ഈ ജഡ്ജ്മെൻറ്റ് മിക്കവാറും എല്ലാവർക്കും അറിയായിരിക്കും. റൈറ്റ് ടു പ്രൈവസി അപ്ഹോൾഡ് ചെയ്തിട്ടുള്ള ജഡ്ജ്മെൻറ്റാണ്. ഈ ജഡ്ജ്മെൻറ്റിലാണ് ആദ്യമായിട്ട് പറയുന്നത് റൈറ്റ് ടു മേക്ക് എ ചോയ്സ് with regard to what? A reproductive choice comes within right to privacy. ഒരു സ്ത്രീയുടെ പ്രൈവസിയുടെ റൈറ്റിൻ്റെ അകത്ത് വരുന്നതാണ് right to reproductive choice. And so it is being protected, constitutionally protected under Article 21 എന്നുള്ളത്. 22-ൽ ഒരു ഇമ്പോർട്ടൻറ്റ് ഡിസിഷൻ പറഞ്ഞു. കല്യാണം കഴിയാത്ത യുവതികൾക്കും റൈറ്റ് ടു അബോർഷൻ ഉണ്ടെന്നുള്ള ഡിസിഷൻ. ദാറ്റ് ഈസ് യു ഫൈൻഡ് ദാറ്റ് ഓൾ വിമൻ regardless of marital status have the right to safe and legal abortion up to 24 weeks. Change in marital status includes unmarried women, ensuring equality, bodily autonomy and privacy under Article 21. അപ്പം കല്യാണം കഴിയാത്ത യുവതികൾക്കും they also have the right to abort. Take for example certain scenarios like ഒരു കുഞ്ഞിനെ അബണ്ടൻ ചെയ്യുന്നു, അതുപോലെ തന്നെ ഒരു സ്ത്രീയെ അബണ്ടൻ ചെയ്യണു ഒരു പാർട്ട്ണർ, എന്തെങ്കിലും ഒരു ഡൈവേഴ്സ് നടക്കുന്ന ഒരു സന്ദർഭം, എന്തെങ്കിലും ഒരു സെപ്പറേഷൻ നടക്കുന്ന സന്ദർഭം, അവിടെ ഒരു സ്ത്രീ പ്രഗ്നൻ്റ് ആണെങ്കിൽ അവരുടെ സ്റ്റാറ്റസ് അവർ മാരീഡ് ആയിരിക്കണം എന്ന് പറയുന്നതിൽ എന്തെങ്കിലും അർത്ഥമുണ്ടോ? ഇല്ലല്ലോ. അതുകൊണ്ട് തന്നെ കോടതി പറഞ്ഞു അൺമാരീഡ്, ഇവരെല്ലാം അൺമാരീഡിൻ്റെ കാറ്റഗറിയിൽ വരാം, അതുകൊണ്ട് ഇവർക്ക് റൈറ്റ് ടു അബോർഷൻ ഉണ്ടെന്ന് പറഞ്ഞു. നൗ ഇതിൻ്റെ ഒരു പ്രത്യേകതയുണ്ട്, ഈ കേസിൻ്റെ ഒരു പ്രത്യേകതയുണ്ട്. ഇതിൻ്റെ അകത്ത് വേറൊരു ചോദ്യം വന്നു. സപ്പോസ് ഒരു സ്ത്രീ മാരിഡാണ്, മാരിറ്റൽ റേപ്പാണ് നടന്നിട്ടുള്ളത്, അവർക്ക് അബോർഷൻ്റെ റൈറ്റ് ഉണ്ടോ എന്ന് ചോദിച്ചു. കോടതി പറഞ്ഞു അബോർഷന് ചെയ്യാനായിട്ട് മാരിറ്റൽ റേപ്പ് വിക്ടിം ഓൾസോ ഹാസ് ദ റൈറ്റ് ടു അബോർട്ട്. അപ്പോൾ കല്യാണം കഴിയാത്ത യുവതികൾക്കും മാരിറ്റൽ റേപ്പ് സംഭവിച്ചിട്ടുള്ള യുവതികൾക്കും റൈറ്റ് ഉണ്ട്, അബോർട്ട് ചെയ്യാനുള്ള റൈറ്റ് ഉണ്ട്. ഇതിൻ്റെ പ്രത്യേകത എന്താണെന്ന് വെച്ചാൽ ഇന്ത്യൻ ലോ ഡസ് നോട്ട് റെക്കഗ്നൈസ് മാരിറ്റൽ റേപ്പ് ആസ് എ ക്രിമിനൽ ഒഫൻസ്. പക്ഷേ through this decision the court said that the woman, if she is a victim of marital rape if she is a victim of marital rape, she is entitled to abort. So എന്ത് പ്രത്യേകതയുള്ളൊരു ഡിസിഷനാണ് നോക്കൂ. Now suppose a woman, there is a grave mental injury by way of her she is suffering due to, or she is having a mental trauma due to she conceiving, whether the court can interfere and accept the petition which is being forwarded by which is being filed by the lady before the court. The Bombay High Court accepted that grave injury to mental health as a valid ground for late term abortions. Late ആയിട്ട് നടക്കുന്ന അബോർഷൻ ആണെങ്കിൽ പോലും ആ സ്ത്രീക്ക് മെൻ്റൽ ഹെൽത്ത് ആ ഒരു ട്രോമയിൽ കൂടെ പൊയ്ക്കൊണ്ടിരിക്കുകയാണ് ഇത് കൺസീവ് ചെയ്തതിന് ശേഷം എന്ന് പറഞ്ഞാൽ ഷീ ഈസ് എൻടൈറ്റിൽഡ് ടു അബോർഷൻ. Now days before, I think if I can recollect properly, January 30th 2026, January 30th 2026 ന് വന്ന ഡിസിഷനാണിത്. ഏറ്റവും ലേറ്റസ്റ്റ് പൊസിഷൻ. Now the Supreme Court, February 6th said that a woman particularly a minor, cannot be forced to continue an unwanted pregnancy against her will while allowing the termination of a 30-week pregnancy of a girl who had become pregnant when she was a minor. Justice Nagaratna and Justice Ujjal Buyan held that what has to be considered in the instant case is the right of the minor child to continue a pregnancy which is ex facie illegitimate in as much as she is a minor and has to face the unfortunate situation of having pregnancy owing to a relationship that she had. The issue is not that whether the relationship is consensual or whether it was a case of sexual assault. Ultimately, the fact is that the child to be is not legitimate, and secondly, the mother of the child does not want to bear the child. And you find that the interesting part is that if the interest of the mother is to take note of, then her reproductive autonomy must be given sufficient emphasis. The court cannot compel any woman, much less a minor, to complete her pregnancy if she is otherwise not intending to do so. എന്താ ഇതിൻ്റെ അർത്ഥം? നിങ്ങൾ വായിച്ചു കാണും. ഒരു മൈനറായിട്ടുള്ള ഒരു കുട്ടി പ്രഗ്നൻ്റ് ആവുമ്പം ആ കുട്ടിക്ക് ആ കുഞ്ഞിനെ അബോർട്ട് ചെയ്യാനുള്ള റൈറ്റാണ് കോടതി, അതും ലേറ്റ് ടേം അബോർഷനാണ് അലോ ചെയ്തത്. അതിനകത്ത് പറഞ്ഞ റീസൺ എന്ന് വെച്ചാൽ എന്തായിരുന്നാലും ആ കുഞ്ഞ് ഇല്ലെജിറ്റിമേറ്റ് കുഞ്ഞാണ്. കൺസെൻഷ്വൽ ആയിട്ടുള്ള സെക്സ് ആണെങ്കിലും അല്ലെങ്കിലും യു ഫൈൻഡ് ദാറ്റ് ആ കുട്ടി ഒരു സെക്ഷൽ വയലൻസിൻ്റെ വിക്ടിം ആണെങ്കിലും അല്ലെങ്കിലും ഒരു സ്ത്രീക്ക് അബോർട്ട് ചെയ്യാനുള്ള റൈറ്റ് ഉണ്ടെന്നാണ് പറഞ്ഞത്. ഒരു മൈനർ പെൺകുട്ടിക്ക് അബോർട്ട് ചെയ്യാനുള്ള റൈറ്റ് ഉണ്ടെന്നാണ് കോടതി ഈ കേസിൽ കൂടെ പറഞ്ഞത്. ഇനി അടുത്ത ക്വസ്റ്റ്യൻ നമ്മുടെ മുമ്പ്, എന്ത് തരത്തിൽ നമുക്ക് ഡെലിവറി, വെജൈനൽ ഡെലിവറി വേണോ, സി സെക്ഷൻസ് വേണോ, നമുക്ക് അത് ചൂസ് ചെയ്യാനുള്ള റൈറ്റ് ഉണ്ടോ എന്നുള്ളത്. യു ഫൈൻഡ് ദാറ്റ് the right to choose the mode of delivery, such as a C-section or a vaginal birth, is being protected constitutionally. While the law supports a woman's choice, it also emphasizes the medical decision, especially the critical situation must be made with the guidance of medical professionals. A mother of X versus State of Maharashtra, which is again a 2026 decision, the Supreme Court asserted that the right to choose the mode of delivery is a part of reproductive autonomy. So, ഏത് തരത്തിൽ വേണം, നിങ്ങൾക്ക് സി സെക്ഷൻ വേണോ, നിങ്ങൾക്ക് വെജൈനൽ വേണോ, അതൊരു സ്ത്രീക്ക് തീരുമാനിക്കാന്നുള്ളതാണ്. അടുത്ത സ്ലൈഡാണ്. ഇനി ചെറിയ ചെറിയ കാര്യങ്ങൾ വിച്ച് ഇസ് വർത്ത് ഇൻട്രസ്റ്റിംഗ്. സോ ഫോഴ്സ്ഡ് സ്റ്റെറിലൈസേഷൻ ആൻഡ് ടു ചൈൽഡ് സ്കീംസും ഫോഴ്സ്ഡ് സ്റ്റെറിലൈസേഷൻ എങ്ങനെയാണെന്നുള്ളത് നിങ്ങൾക്കറിയാം. Sterilization process is mostly state-sponsored projects. Now, forced sterilization in India, particularly targeting the poor, the rural and the vulnerable women through state-sponsored sterilization camps, has been a significant human rights concern leading to major judicial interventions. Despite female sterilization being riskier and more complex than male sterilization, the family planning program tend to focus on women. In India, female sterilization far outnumber male sterilizations. And you find that in Ramakant Rai versus Union of India, which is a 2005 decision following the reports of the high number of deaths in sterilization camps, the Supreme Court in 2005 passed directions to establish guidelines for sterilization procedures. Next slide. ഇതൊരു ഭയങ്കര ഇൻട്രസ്റ്റിംഗ് ആയിട്ടുള്ള കേസാണ്. ഞാൻ ദേവികയുടെ കേസ് പറഞ്ഞപ്പം ഒന്ന് പറഞ്ഞിരുന്നത്. 2014 ബീഹാറിൽ ഒരു സ്റ്റെറിലൈസേഷൻ ക്യാമ്പ് നടത്തി. ആൻഡ് ഇറ്റ് വാസ് ഡൺ ഇൻ എ ഹോസ്പിറ്റൽ. Actually, it was a non-functional private health facility where 83 women underwent sterilization through laparoscopic tubectomy. All the 83 women were discharged within 30 minutes to an hour of the procedure. After they reached home, many women started to vomit at night. The next day, their conditions deteriorated with further complications which required hospitalization. Next slide. In the incident, 13 women who belonged to the SAST and other backward classes lost their life. All of them were young mothers below 30 years of age. Many had infants as young as 3 months old who were being breastfed at that time. Chhattisgarh court took a suo motu action. While the case was registered, the Supreme Court was hearing the Devika Bishwas case, and immediately this particular case was transferred to the Supreme Court. And in the Devika's case, you find that the court asserted that sterilization programs in the absence of adequate health measures by the state cannot be allowed, and a lot of guidelines were being brought about. Next slide. Two-child norms. In India, the two-child norms often emerge as a local level policy restricting welfare benefits to or panchayat eligibility. Panchayat eligibility എന്ന് പറഞ്ഞാൽ വേറൊന്നുമല്ല, പഞ്ചായത്ത് ഇലക്ഷന് നിൽക്കണമെങ്കിൽ 2 കുഞ്ഞുങ്ങളെ പാടുള്ളൂ, അതിന് മുകളിലുള്ളവരെ ഇലക്ഷന് എലിജിബിലിറ്റി പോകും. ഇത്രയേ ഉള്ളൂ, ചെറിയ കാര്യം. പക്ഷേ അത് ചെറിയ കാര്യമല്ല. നമ്മുടെ റൈറ്റ് ടു ബി റെപ്രസെൻറ്റഡ് ഇസ് ബീങ് വയോലേറ്റഡ്. So this was taken up in Javed versus State of Haryana 2003. You'll be surprised to note that the Supreme Court said that the two-child norm is constitutional. So thus, legally speaking, the women are still not the final arbiters or the judges of the right to abort. It is continuing to be based on medical gatekeeping, which determines reproductive autonomy. Next slide. Now, recognition of menstrual health as a part of reproductive right. On January 30th, 2026, the Supreme Court delivered a game-changing judgment. Hitherto, menstruation of a woman was considered as a stigma. The Supreme Court affirms through a judgment that menstrual health and hygiene forms a part of Article 21 of the Constitution, right to reproductive autonomy. The court gave certain directions with regard to the menstrual hygiene which needs to be maintained in the schools. ഒന്ന് നോക്കിക്കേ, free sanitary pads, preferably biodegradable, എല്ലാ സ്കൂളുകളിലും വേണം. Functional, clean and gender segregated toilets വേണം. Safe disposal system for menstrual waste. Water, soap and privacy for menstruating student. Education on menstruation and puberty ought to be included in the school syllabus. And through campaigns, breaking of the circle of mutually enforced periods related social taboo should be achieved. In case the school does not, even if it is a private school, if it does not conform to these standards, its recognition can be taken away by the state. So this is the level of or the impact of the judgment which came about in this year itself. Okay, so this has become a constitutionally vested right. But still we have a long way to go. No laws for protection of menstrual rights. We don't have, only the Supreme Court judgments we have. We have only policies and programs. Of late, the government of Kerala in 2024 has granted 2 days menstrual leave for female students of higher educational institutions, universities and colleges, including Cochin University of Science and Technology and the University ഉൾപ്പെടെ എല്ലാ യൂണിവേഴ്സിറ്റീസും കേരളത്തിൽ യു ഫൈൻഡ് ദാറ്റ് 2 ദിവസം പെൺകുട്ടികൾക്ക് ലീവ് കൊടുക്കാറുണ്ട്. മെൻസ്ട്രൽ ലീവിന് ഞങ്ങളെല്ലാവരും അറ്റൻഡൻസ് 2 ദിവസം അവർക്ക് എലിജിബിളാണ്. പക്ഷേ ഇത് തന്നെ സ്ത്രീകൾക്കും വേണ്ടേ? ഓഫീസിൽ നമ്മൾ ഓഫീസിൽ പോകണം, ഓഫീസിൽ മാത്രമല്ല വീട്ടു ജോലിക്ക് വരുന്ന ഒരു സ്ത്രീക്ക് ഉൾപ്പെടെ ഇതൊരു അവകാശമല്ലേ? ബട്ട് this is a stepping stone. Probably we can expect that also to come in within a short while. The Supreme Court has not directly legalized paid menstrual leave as a basic right. However, by recognizing the issue of menstrual health as a part of Article 21, the court has laid strong foundation for the future legislation or authorities to combat period leave policies. So, government പീരീഡ് ലീവ് പോളിസീസ് കൊണ്ടുവരാമെന്നുള്ളതേ ഉള്ളൂ. നമ്മുടെ ഇന്ത്യയിൽ തന്നെ 2 സംസ്ഥാനങ്ങളിലാണ് എൻ്റെ അറിവിൽ പീരീഡ്സ് ലീവ് കൊടുത്തിട്ടുള്ളത്. ഒന്ന് കേരളവും മറ്റൊന്ന് കർണാടകയാണ്. ബാക്കി ഒരു സംസ്ഥാനത്തും അത് നടപ്പിലായിട്ടില്ല. അടുത്ത സ്ലൈഡ്. Maternity leave as a right. Maternity benefits in India are primarily governed by Chapter 6 of the Code on Social Security 2020, which consolidates and replaces the Maternity Benefit Act of 1961. Maternity Benefit Act ne pattiyekka ivida charcha nadanittundavu. ഞാൻ അതിൻ്റെ ഒരു ചെറിയ കാര്യമേ പറയുള്ളൂ, കൂടുതൽ പറയില്ല. സോ ഈ ലേബർ കോഡ് വന്നത് 2025 ഈ സോഷ്യൽ സെക്യൂരിറ്റി കോഡ് ലേബർ കോഡിൻ്റെ ഭാഗമായിട്ട് വന്നത്. അതിൻ്റെ ഒരു പ്രത്യേകത എന്ന് പറഞ്ഞാൽ അൺഓർഗനൈസ്ഡ് സെക്ടേഴ്സിലും ഈ ലേബർ കോഡ് ബാധകമാക്കി. സോ പെയ്ഡ് ലീവാണ്, 26 ആഴ്ച പെയ്ഡ് മെറ്റേണിറ്റി ബെനിഫിറ്റ് ഫോർ ദ ഫസ്റ്റ് 2 children up to 8 weeks pre-delivery, 12 weeks for women with 2 or more children, 12 weeks for പ്രത്യേകത എന്ന് വെച്ചാൽ അഡോപ്റ്റീവ് ഓർ സറോഗേറ്റീവ് മദേഴ്സിനും 12 ആഴ്ച ലീവ് കൊണ്ടുവന്നു എന്നുള്ളതാണ്. നെക്സ്റ്റ് സ്ലൈഡ് പ്ലീസ്. ഇതൊക്കെ നിങ്ങൾക്ക് അറിയാം. നഴ്സിംഗ് ബ്രേക്സ് ഫോർ ദ ചൈൽഡ് ഇഫ് ദ ചൈൽഡ് ഇസ് 15 months below, the medical bonus for pre and postnatal care, option to work from home, mutually agreed term ആയിട്ട് എംപ്ലോയറുമായിട്ട് ഒരു വർക്ക് ഫ്രം ഹോം അറേഞ്ച്മെൻറ്റ് ഉണ്ടാക്കാൻ പറ്റുമെങ്കിൽ അത് ചെയ്യാം കുഞ്ഞിനെ നോക്കാനായിട്ട്. പ്രൊട്ടക്ഷൻ എഗെയിൻസ്റ്റ് ഡിസ്മിസൽ ഓർ അഡ്വേഴ്സ് ചേഞ്ചസ് ഡ്യൂറിങ് പ്രഗ്നൻസി, ക്രഷ് ഫെസിലിറ്റീസ് മെയ്ഡ് മാൻഡേറ്ററി ഇൻ എസ്റ്റാബ്ലിഷ്മെൻറ്റ്സ് വിത്ത് 50 or more. ഇതിനകത്ത് കുറച്ച് ചെറിയ ഡ്രോബാക്സ് ഉണ്ട്. നമുക്ക് കാണാൻ പറ്റും കോഡ് ഭയങ്കര കവറേജാണ്. എന്താണ് അൺഓർഗനൈസ് സെക്ടർ മൊത്തം കവർ ചെയ്യണമെന്നാണ് പറയണത്. പക്ഷേ നമുക്ക് കാണാൻ പറ്റും ഈ കോഡ് എസ്റ്റാബ്ലിഷ്മെൻറ്റ്സ് വിത്ത് 10 or more വർക്കേഴ്സിന് മാത്രമേ അപ്ലിക്കബിൾ ആവുള്ളൂ. അല്ലാത്ത സ്ഥാപനങ്ങളിലൊന്നും ഇത് അപ്ലിക്കബിൾ ആവില്ല. രണ്ടാമത്തേത് ഇത് മിക്കവാറും ബിസിനസ്സുകാർ ഫോളോ ചെയ്യാത്ത ഒരു നിയമമാണ്. ഇത് MSMEകൾക്കും അപ്ലിക്കബിൾ ആക്കണം, അതും ആക്കിയിട്ടില്ല. അപ്പോൾ ഇതിന് എൻഫോഴ്സ്മെൻറ്റ് എങ്ങനെയായിരിക്കും എന്നുള്ളത് ഇറ്റ് ഈസ് ഡൗട്ടഡ്. In K. Umadevi versus Government of Tamil Nadu, the Supreme Court of India established that maternity leave is a fundamental right and stemming from a woman's reproductive right, dignity and health rather than a mere statutory benefit. ഒരു ലെജിസ്ലേഷൻ വന്ന ഒരു റൈറ്റ് ഒന്നുമല്ല, അത് ബേസിക് ആയിട്ടൊരു കോൺസ്റ്റിറ്റ്യൂഷണൽ റൈറ്റ് ആണെന്ന് കോടതി പറഞ്ഞു. നെക്സ്റ്റ്. February 4, 2026, ഇത് you find that Kerala High Court came up with a decision. Maternity leave is a fundamental constitutional right and cannot be treated like regular or discretionary leave. എന്ന് പറഞ്ഞാൽ മെറ്റേണിറ്റി ലീവ് മറ്റ് ലീവുകളുമായിട്ട് എംപ്ലോയറിന് ടൈപ്പ് ചെയ്യാൻ പറ്റില്ല. മെറ്റേണിറ്റി ലീവ് എന്ന് പറയുമ്പോൾ സ്റ്റാറ്റ്യൂട്ടിനകത്ത് പറഞ്ഞ അത്രയും ലീവുകളും ആ സ്ത്രീക്ക് കൊടുത്തിരിക്കണം. അത് കഴിഞ്ഞിട്ട് അവർക്ക് ക്യാഷ്വൽ ലീവ്, അവർക്ക് വേറെ ഏതൊക്കെ എലിജിബിൾ ലീവ് ഉണ്ടോ അതെല്ലാം അവർക്ക് അപ്ലിക്കബിൾ ആണെന്ന് കോടതി പറഞ്ഞു. The court underscored that maternity leave is a part of the woman's reproductive right and not a statutory benefit. A woman's right to pregnancy moves from Maternity Benefit Act. Thus, when legislature and executive fail to assert the rights, courts have come to the protection of reproductive rights of women, including maternity rights. Adutha slide. Third gender and their reproductive rights. Lesbian, gay, bisexual, transgender, queer rights in India have expanded from the legislative side, not from the legislative side, but from the judicial contribution. There are no restrictions in India on sex between men and men and between women and women. The decision is available. You can just have a glimpse of it if you want. India does not recognize same-sex marriages. Same-sex marriage in India is recognized alla. Now, while the 2018 decriminalization of homosexuality was a major win, the same-sex marriage is not legally recognized, which is limiting the transgenders from access to joint adoption, assisted reproductive technology, and surrogacy, which often you find that stresses that a married heterosexual couple only can claim. That is, LGBTQ community or the third gender, they cannot claim the right to adopt or have a surrogate child or have a child through assisted reproductive technology. So, idana adinte position. Next slide. The Surrogacy Regulation Act of 2021 and the Assisted Reproductive Technology Act 2021 favor traditional family structures, creating legal barriers for the LGBTQ individuals to access these services. So there's a long way to go for the third gender as well. The Supreme Court in 2023 in Supriya's case declined to legalize same-sex marriage, which has a direct impact on the LGBT couples. Adutha slide. vulnerable among the vulnerables ignored. You find that there is a legislative silence with regard to vulnerable among the vulnerables. Dalit and Adivasi women are denied maternity care and subjected to forced sterilization. You saw the Bilaspur sterilization camp case. You found that in Devika Bishwa's case. So this is rampant. Disabled women are quite frequently excluded from sex education and denied bodily autonomy. LGBT again are being excluded. The poor and the rural face harshest consequences due to inadequate infrastructural facility. These groups often face multiple layers of discrimination compounding the vulnerability. The failure of the state to address these vulnerability is an expression of systemic indifference. As I conclude, I have few words to say. If India is determined to empower its women, it has to remove the walls, legal, medical, and cultural, that prevent their control over their reproductive lives. The law needs to inscribe what the Constitution guarantees: the right to live with dignity, the right to privacy, and the right to over one's own body. It's time for us to change. Thank you, thank you. I thank the organizers for giving me such a golden opportunity to present my ideas here today. Thank you for your patient listening. Questions are always welcome. ഞാൻ പറഞ്ഞൊന്നും ഇഷ്ടമായില്ല. അപ്പോൾ ചോദിച്ചോളൂ, എന്തെങ്കിലും ഒരു ചെറിയ ചോദ്യം. എനിക്കൊരു സെൻസ് ഓഫ് സാറ്റിസ്ഫാക്ഷൻ ബിഫോർ ഐ ലീവ് ദിസ് ഡയസ്. എ സെൻസ് ഓഫ് സാറ്റിസ്ഫാക്ഷൻ. എന്തെങ്കിലും ഒരു ചോദ്യം. Anything I have left out? At least any criticism of what I said? Nothing? Okay, okay. Hi.
Good evening, ma'am. Myself Arundhati. I am a student of BSc Psychology. എനിക്ക് ചോദിക്കാനുള്ള ചോദ്യം എന്ന് വെച്ച് കഴിഞ്ഞാൽ there were several things that were said here, including making menstrual pads free. Free ആയിട്ട് കൊടുക്കണം എന്നാണ് actually rule, but as a student, I have to still say that we are still being charged. Like for a single piece, 10 to 20 rupees ആണ് ഞങ്ങളുടെ കയ്യിൽ നിന്ന് വാങ്ങുന്നത്. ഇറ്റ്സ് നെവർ ഫ്രീ ഫോർ അസ്. ആൻഡ് ക്ലാസ് റൂംസിൽ തന്നെ ചില സമയത്ത് ഫീമെയിൽസ് ആണ്, ഞങ്ങൾക്ക് മേ ബി എൻഡോമെട്രിയോസിസ് പോലുള്ള കണ്ടീഷൻസ് ഉണ്ടാവും, PCOS, PCOD അങ്ങനത്തെ കണ്ടീഷൻസ് വരുമ്പോൾ നോർമലി ഹെവി ആയിട്ടുള്ള ക്രാംസ് വരും നമുക്ക്. അങ്ങനെ വരുമ്പോൾ ജസ്റ്റ് ഒന്ന് ലൈ ഡൗൺ ചെയ്യുകയാണെങ്കിൽ തന്നെ ടീച്ചേഴ്സിൻ്റെ ഭാഗത്ത് നിന്ന് സംടൈംസ് ഞങ്ങൾക്ക് വളരെ മോശമായിട്ടുള്ള ഇൻറ്ററാക്ഷൻസ് നേരിടേണ്ടി വന്നിട്ടുണ്ട്. അതായത് ദേ സേ ദാറ്റ് വി ആർ ഓവർ റിയാക്ടിങ്, അവർക്കും ഇതൊക്കെ വരാറുണ്ട്, ദേ ഡോണ്ട് ഡൂ സച്ച് തിങ്സ്, വൈ ആർ യു ലൈങ് ഡൗൺ, ജസ്റ്റ് ടേക്ക് എ ടാബ്ലറ്റ്, ഇങ്ങനെയൊക്കെയുള്ള കാര്യങ്ങൾ കേൾക്കാറുണ്ട്. ആൻഡ് റീസെൻ്റ്ലി ഇതുപോലെ ഒരു പീരിയഡ് ഷെയ്മിങ് കാരണം ഐ തിങ്ക് ഇൻ ബംഗളൂരു സ്റ്റുഡൻറ്റ് ഡൈഡ് ഔട്ട് ഓഫ് സ്ട്രെസ് ഇൻഡ്യൂസ്ഡ് ഹെമറാജ് ഇൻ ബ്രെയിൻ. സോ ഇങ്ങനത്തെ സാഹചര്യങ്ങളിൽ നമ്മൾക്ക് എന്താണ് ചെയ്യാൻ പറ്റുക, ലീഗലി ഓർ നോൺ ലീഗലി?
നല്ല ചോദ്യമാണ് മോളെ, നല്ലൊരു ചോദ്യം. ഐ അപ്രിഷിയേറ്റ് യുവർ ക്വസ്റ്റ്യൻ സോ മച്ച്. ഓക്കെ, ഐ എം ഓൾസോ എ ടീച്ചർ. ഇറ്റ്സ് എ ലെസൺ ഫോർ മീ ആസ് വെൽ, റൈറ്റ്? Mole, you find that in every educational institution, I don't know to what extent your university, you have a students' grievance cell and you have a faculty coordinator for it. Am I right? So this is something, a basic right, which you find that at present the government is also guaranteeing you this right. ഇല്ലേ, നമുക്ക് 2024 തൊട്ട് നമ്മൾ കോളേജ് വിദ്യാഭ്യാസത്തിലെങ്കിലും അത് വന്നിട്ടുണ്ട്. സോ യു ക്യാൻ ഇമ്മീഡിയറ്റ്ലി റിപ്പോർട്ട് ദ മാറ്റർ, ടേക്ക് അപ്പ് ദ മാറ്റർ വിത്ത് ദ ഹയർ അതോറിറ്റീസ്. some women would have done this. That is why we are enjoying the benefit today, right? ഏതോ ഒരു സ്ത്രീ, ഏതോ ഒരു പെൺകുട്ടി നമുക്ക് വേണ്ടി എവിടെയോ ശബ്ദങ്ങൾ മുഴക്കിയിട്ടുണ്ട് അല്ലേ? അതിൻ്റെ ഒരു എക്കോ ആണ് നമുക്കൊക്കെ കിട്ടിയത്, അതിൻ്റെ ബെനിഫിറ്റ്. It is slow. I do agree it is slow. But we have got it right. Now, it is our responsibility to see that it is being enforced properly. Now, you find that any right for that matter, there might be violation of it. People might, of late, body shaming has become one of the, it has also been questioned by the court, and the court said that no body shaming anymore. See, it's a slow transformation of a progressive society, which we need to accept. There are a lot of people who are, including your teachers, I would say that, who have a retrograde attitude for all these things. നമ്മുടെ വീട്ടിൽ തന്നെ നമുക്ക് പീരീഡ്സ് ആകുമ്പോഴേക്കും ഇറ്റ് ഈസ് ബീങ് സെഡ് ദാറ്റ് വി വെർ, അറ്റ്ലീസ്റ്റ് നിങ്ങളുടെ പ്രായത്തിലല്ലായിരിക്കും, ഞങ്ങളുടെയൊക്കെ സെപ്പറേറ്റ് റൂമാണ്, സെപ്പറേറ്റ് ആരുടെ സംസാരിക്കാൻ പാടില്ല. ദെർ വാസ് എ ലോട്ട് ഓഫ് സ്റ്റിഗ്മറ്റൈസേഷൻ. നൗ ഇറ്റ് ഹാസ് ചേഞ്ച്ഡ്. നോ, സോ ദാറ്റ് ഈസ് ബിക്കോസ് യു സ്റ്റുഡൻസ് or the younger generation have become more assertive as to this is not the way you need to, this is a body condition. And this is not only a body condition, this has also got a mental condition tied up with it. So please accept that. And that has been accepted by the courts as well. That is why it has been made a part of your curriculum. Earlier, when we were hesitant to say that we are on periods to our fellow classmates, even boys. ഇപ്പം അങ്ങനെയാണോ? അല്ല. So it has gone a transformation. So it is up to the students to approach the concerned authority and say that this is the right. Probably if you have the support of the law എടുത്തിരുന്നെങ്കിൽ കുറച്ചും കൂടെ അസേർട്ടീവായിട്ട് പറഞ്ഞേനെ. ഞങ്ങളുടെ ഇൻസ്റ്റിറ്റ്യൂഷനിലൊന്നും അങ്ങനെയൊന്നും നടക്കില്ല. Because Dr. Shiva might be knowing that they are very assertive. They will say that no, ഇതാണ് ഞങ്ങളുടെ പൊസിഷൻ. You have to provide us with the minimum requirement. So this is their mola. This is the law, and law becomes more powerful only when you try to seek the remedy and try to enforce it. So I hope that you will do that.
Thank you, ma'am.
Thank you for that question as well. Any more questions? So thank you so much.
Do we have any more questions? ഈ 2 ദിവസത്തെ കോൺക്ലേവ് നടന്ന ഏതെങ്കിലും വിഷയത്തിൽ എന്തെങ്കിലും ചോദിക്കാനും പറയാനും ഉണ്ടെങ്കിൽ ഈ ഒരു അവസരം നിങ്ങൾക്ക് നല്ല രീതിയിൽ ഉപയോഗിക്കാവുന്നതാണ്. We might not get such venues where you can share your thoughts, ask your doubts, clarify whatever is lying in your mind. So please come forward with the questions. Even with the earlier sessions, if you have something left in your mind, you can shoot the questions. We have all the experts around here to answer you, to clarify you. So ചെറിയൊരു ഡൗട്ട് ആണെങ്കിലും എന്താണെങ്കിലും, maybe you want to share an experience, share a thought, not a question. I think you can do that as well. Anybody from the department? Is that all? Please, yes. Mic തരും സിസ്റ്റർ, 1 minute. Please.
മാം, ഒരാളുടെ ജനിക്കാനുള്ള അവകാശത്തെ ലോ എങ്ങനെയാണ് പ്രൊട്ടക്റ്റ് ചെയ്യുന്നത്? അതായത് അത് മദറിൻ്റെ ഓട്ടോണമിയെ ഡിപ്പെൻഡ് ചെയ്തിരിക്കുന്നതാണോ എന്ന് എനിക്കൊരു സംശയം.
മാഡം, അത് സിസ്റ്റർ ഞാൻ ഒരു ഇത് പറഞ്ഞോട്ടെ. സി, എപ്പോഴും ഭയങ്കര കണ്ടൻഷ്യസ് ആയിട്ടുള്ളൊരു എലിമെൻ്റാണ് റൈറ്റ് ഓഫ് ദ അൺബോൺ ചൈൽഡ് വിസാവീസ് ദ റിപ്രൊഡക്റ്റീവ് റൈറ്റ് ഓഫ് ദ മദർ. ഓക്കെ, നൗ യു ഫൈൻഡ് ദാറ്റ് ഇത് കണ്ട് ഈ ഒരു കോൺഫ്ലിക്റ്റാണ് പലപ്പോഴും ഡിസിഷൻസും ലെജിസ്ലേഷൻസും നമുക്ക് കാണാൻ പറ്റുന്നത്. അമ്മയ്ക്ക് ഫുൾ ഓട്ടോണമി കൊടുക്കാതെ വരുന്നത് ബിക്കോസ് ഫീറ്റലിൻ്റെ അബ്നോർമാലിറ്റി എന്തെങ്കിലും ഉണ്ടെങ്കിൽ മാത്രം മതി എന്നുള്ളത് പറയാനായിട്ട്. നൗ you're talking about a person who is not in existence or who has only a chance of coming into existence. But I am talking of a person who is fully alive, is fully conscious, and probably he or she might not be, anticipatory or a rape victim or a sexual violence in a victim. അങ്ങനെ ഒരു കുട്ടിക്ക് അല്ലെങ്കിൽ ഒരു മൈനർ വിക്ടിം. സോ ഇങ്ങനെയുള്ള സർക്കംസ്റ്റൻസിൽ ആ കുഞ്ഞിനെ നോക്കി നടത്താണ്ട് ഒരു മെൻ്റലി റിട്ടാർഡഡ് ആയിട്ടുള്ളൊരു അമ്മ ഇങ്ങനെയുള്ള സാഹചര്യത്തിൽ ഷുഡ് നോട്ട് ദാറ്റ് വുമൺ ബി ഗിവൺ ദ ഫുൾ ഫ്രീഡം? ബിക്കോസ് ഒരു കുഞ്ഞ് ഈ ലോകത്ത് ജനിച്ചു വന്ന അതിൻ്റെ മനസ്സിൻ്റെ അകത്ത് തോന്നണേ, എൻ്റെ അമ്മയ്ക്ക് എന്നെ ആദ്യം മുതലേ ഇഷ്ടമല്ലായിരുന്നു. അപ്പോൾ ആ അമ്മ എന്തെങ്കിലും പറഞ്ഞാൽ പോലും ആ കുഞ്ഞ് ആ ഒരു കാഴ്ചപ്പാടിലേ ആ അമ്മയെ കാണുള്ളൂ. അങ്ങനെ ഒരു കുഞ്ഞിന് എന്ത് തരത്തിലുള്ള ഇമോഷണൽ സന്തോഷമാണ് കിട്ടാൻ പോകുന്നത്? ഐ ആം ടോക്കിംഗ് ഇൻ ടേംസ് ഓഫ് ദി അൺബോൺ ചൈൽഡ്. ആ കുഞ്ഞിന് എന്തായിരിക്കും അതിൻ്റെ മനസ്സിൽ കൂടെ പോകുന്നത്? ഈ അമ്മയ്ക്ക് എന്നെ തുടക്കം തൊട്ടേ ഇഷ്ടമല്ലായിരുന്നു എന്നാണ് തോന്നുന്നത്, ഇല്ലേ? ഈ ലേഡി അണ്ടർഗോ ചെയ്യുന്ന ട്രോമ അവരുടെ മനസ്സിൻ്റെ അകത്തും അവരുടെ ശാരീരികമായിട്ടും ഫിനാൻഷ്യലി എല്ലാം കൊണ്ടും സോഷ്യലി അവരെ ആൾക്കാർ കാണുന്നതും എല്ലാം അവരുടെ മനസ്സിൽ കൂടെ പോകുന്നുണ്ടാവും. അത് ഇറ്റ് ക്യാൻ അഫക്ട് ദ ഹെൽത്ത് ഓഫ് ദ ചൈൽഡ് ഓൾസോ ഇൻ ദ വൂം. So I would say that it is always that there is a balance, there is a need for balance. Of course, I wouldn't say that when you have a consensual sex and then you go for conceiving, but when your partner abandons you, what is your situation? You don't have the means to live, to take care of the child. So what would be the plight of the mother who is living, is a living human being as that of me and you? So that is more important. I personally believe that is more important, because a healthy mother leads to the nourishment and of a healthy baby, a healthy future. So that's it.
Thank you, ma'am.
Thank you, ma'am, for answering the questions. Do we have any more?
മാഡം, വുമൺ പ്രൊട്ടക്ഷൻ ഓഫീസറാണ്, പാലക്കാട്. അപ്പോൾ നമ്മുടെ അടുത്ത് വരുന്ന കേസുകളിൽ ഇപ്പോൾ കൂടി വരുന്ന ഒരു ട്രെൻഡ് റീപ്രൊഡക്റ്റീവ് ഹെൽത്തുമായിട്ട് ബന്ധപ്പെട്ട് തന്നെ പോസ്റ്റ്മോർട്ടം ഡിപ്രഷൻ പോലുള്ള അവസ്ഥകളിലൂടെ സ്ത്രീകൾ കടന്നു പോകുന്നുണ്ട്. അത്തരം ധാരാളം കേസുകൾ റീസെൻ്റായിട്ട് അഡ്രസ്സ് ചെയ്യേണ്ടി വരാറുണ്ട്. അപ്പോൾ അത്തരം കേസുകളിൽ ആ കുട്ടിക്ക് ബയോളജിക്കലായിട്ടുള്ള ആ പ്രോസസ്സ് കഴിഞ്ഞതോടുകൂടി ഒരു അടുത്ത ടൈമിൽ ഉണ്ടാകുന്ന ഒരു കാര്യമാണെന്നുള്ള രീതിയിൽ അത് ആക്സെപ്റ്റ് ചെയ്യാനോ അതിൻ്റെ ഒരു ഭാഗമായിട്ട് വരുന്ന അവസ്ഥയാണെന്നും അത് ചികിത്സ വിധേയമാകുമ്പം സാധാരണ ജീവിതത്തിലേക്ക് പോകുന്നു, ഫാമിലി ലൈഫ് നോർമലായിട്ട് പോകുന്നുള്ളൊരു ആക്സെപ്റ്റൻസ് ഇല്ലാത്തത് കൊണ്ട് നമുക്ക് ഒന്നുകിൽ ഡിവോഴ്സ് അല്ലെങ്കിൽ ആ കുട്ടിയെ ഉപേക്ഷിക്കുന്ന ഒരവസ്ഥയിലേക്ക് വരാറുണ്ട്. അപ്പോൾ അത് അഡ്രസ്സ് ചെയ്യുന്നത് സംബന്ധിച്ച്
നല്ല ചോദ്യമാണ് മാഡം, നല്ലൊരു ചോദ്യം. എൻ്റെ കൂടെ ഞാനൊരു വുമൻ സ്റ്റഡി സെൻറ്റർ, ഞങ്ങളുടെ UGC സപ്പോർട്ടഡ് വുമൻ സ്റ്റഡി സെൻറ്റർ ഉണ്ട് കിസാറ്റിൽ. അപ്പോൾ അവിടെ ഞാൻ അതിൻ്റെ അഡ്വൈസറി കമ്മിറ്റി മെമ്പറാണ്. അപ്പം എൻ്റെ കൂടെ പോസ്റ്റ് ഡോക്ടറൽ PhDക്ക് വേണ്ടിയിട്ട് ഒരു കുട്ടി അപേക്ഷയായിട്ട് വന്നു. അപ്പം ആ കുട്ടിയുടെ അടുത്ത് ഞാൻ പറഞ്ഞത്, ആ കുട്ടി ഒരു ജെൻഡർ സ്റ്റഡീസിൽ MA കഴിഞ്ഞ ഒരു കുട്ടിയാണ്. അപ്പം ഞാൻ പറഞ്ഞു, നിങ്ങൾ ഒരു കാര്യം നോക്കൂ, നമുക്ക് പലപ്പോഴും കാണാൻ പറ്റും ഏറ്റവും വിദ്യാഭ്യാസമുള്ള സ്ത്രീകളിൽ പോലും ഈ PhD ഒക്കെ ചെയ്യുന്ന സമയത്ത് MSc MA MSc ഒക്കെ കഴിയുന്ന സമയത്ത് തന്നെ ആൾക്കാർ കല്യാണം കഴിക്കും, പെൺകുട്ടികൾ. PhD ലെവലിലാവുമ്പം ഒട്ടും PhD വർക്ക് ലോഡ്, കുഞ്ഞിനെ നോക്കണം, ദിവസവും അറ്റൻഡൻസ് ഉണ്ട് റിസർച്ച് സെൻറ്ററിൽ, എന്നില്ലെങ്കിൽ ജോലിക്ക് പോകണം, ഭയങ്കര തിരിച്ച് വീട്ടിൽ വന്നു കഴിഞ്ഞാൽ ജോലി, വീട്ടിലെ ഡൊമസ്റ്റിക് കോഴ്സ്, ഇതെങ്ങനെ മാനേജ് ചെയ്യും? ഇത് ഭയങ്കര പാടാണല്ലോ, വർക്ക് ലൈഫ് ബാലൻസ്. അപ്പം ഇതിനെപ്പറ്റി നിയമം എന്ത് പറയണു? നിയമത്തിൻ്റെ അകത്ത് അബ്സല്യൂട്ട്ലി ഇറ്റ് ഈസ് വാക്ക്. ലോ ഈസ് സൈലൻറ്റ് ഓൺ ദാറ്റ്. ബിക്കോസ് പോസ്റ്റ്മോർട്ടം ഡിപ്രഷൻ മെൻ്റൽ ഹെൽത്ത് കെയർ ആക്ട് ഉണ്ട് മാഡം, 2017 മെൻ്റൽ ഹെൽത്ത് കെയർ ആക്ട്. ഇറ്റ് ഈസ് ഓൾസോ സൈലൻറ്റ്. It doesn't say about what is the mental health of a woman after delivery. How is she going to balance her life with work as well as domestic chores? How is she going to take care of this? We don't have any programs in the state also. State level or in India also, we don't have any programs which, which we can say that it is giving importance to this group of women. Because yesterday I had a conversation with my auntie. So she was telling me, I'm sitting at home, I didn't do much work. I had to take care of 3 kids, that's it. So I said, it's not that easy as you say. I don't feel that it is that easy as you say. Because you are doing more or less more work than me, I would say. At least I have a help at home. I have a maid or a house help. You don't have that also, and you have to take care of 3 kids. Is that simple? So you find that often women themselves feel that they are supposed to do all these things. ഇല്ലേ മാഡം? നമ്മളാണ് ഇതെല്ലാം ചെയ്യേണ്ടത്. നമ്മൾ ചെയ്താലേ ഇത് പെർഫെക്റ്റ് ആവുള്ളൂ. I have numerous occasions of addressing audience where I talk about rights of women. Dr. Shiva also will be knowing about that. Like we get an opportunity on March 8th, ma'am, mostly. March 8th എന്ന് പറഞ്ഞാൽ ഞങ്ങൾക്ക് കൊയ്ത്താ ലോ പഠിപ്പിക്കുന്ന ടീച്ചേഴ്സിനൊക്കെ. വുമൺ റൈറ്റ്സ് എല്ലാ സ്ഥലത്തും വുമൺ റൈറ്റ്സിനെ പറ്റി പോഷ് ആക്ടിൻ്റെ ക്ലാസ്സുകൾ. ഇത് തന്നെയാണ് കളി. You find that to imbibe in day-to-day affairs, it has become more difficult. But that doesn't mean that it's doomsday. Illa. We do have prospects. There are a lot of men who are very progressive. At least a couple of them you can find them here. Okay? So we need to assert what we are. At the state level, we need to initiate policies and programs where you can address the mental health of these category of women. Not only that postpartum, also during the phase of they carrying the thing. But എനിക്ക് എൻ്റെ ഒരു അണ്ടർസ്റ്റാൻഡിങ്ങിന് ഇപ്പോഴത്തെ കൗൺസിലിംഗ് ഉണ്ട്. പ്രഗ്നൻ്റ് ആയിട്ടുള്ള വുമണിന് കൗൺസിലിംഗ് ഉണ്ട്. ബട്ട് postpartum you don't have that counseling. So that's a very relevant question. We don't have any law as such, but let's hope that again the Supreme Court or the legislatures or the government will come up with such policies and programs. Thank you.
Thank you. Now may I please call upon Srimati Savita PG, Women Protection Officer, Kasaragod, to kindly present the memento to Dr. Vani Kesariye and also express a gratitude.
Good evening all dignitaries and my friends, students and who participate this program. ഇന്ന് രാവിലെ മുതൽ നമ്മൾ ഒരു സബ്ജക്റ്റ് ഇംപ്ലിമെൻറ്റേഷൻ ഓഫ് ലെജിസ്ലേഷൻ ഫോർ വുമൺ ക്രിട്ടിക്സ് എന്ന സബ്ജക്റ്റിനെ സംബന്ധിച്ചാണ് ഇന്നത്തെ സെക്ഷൻസ് മുഴുവൻ കൈകാര്യം ചെയ്തിരുന്നത്. അപ്പോൾ അതിലെ ലാസ്റ്റ് സെക്ഷനായിട്ടുള്ള വുമൺ റീപ്രൊഡക്റ്റീവ് റൈറ്റ്സ് ഗ്യാപ്സ് ഇൻ എക്സിസ്റ്റിംഗ് ലെജിസ്ലേഷൻ എന്ന സബ്ജക്റ്റിനെ പറ്റി വളരെ സിമ്പിളായി വളരെ എല്ലാവർക്കും മനസ്സിലാവുന്ന രീതിയിൽ നല്ല ഉപകാരപ്രദമായ രീതിയിൽ സ്ത്രീകളുടെ ജീവിതവും അവരുടെ റീപ്രൊഡക്റ്റീവ് സിസ്റ്റം അതിൽ വരുന്ന ലോസ് അത് വരുന്ന ക്രിട്ടിക്സ് അതിൽ വരുന്ന പല കാര്യങ്ങളും മെറ്റേണിറ്റി മുതൽ നമ്മുടെ മെൻസ്ട്രൽ പീരീഡ് വരെയുള്ള കാര്യങ്ങളിലെ ലോസിനെ പറ്റിയും അതിൻ്റെ ക്രിട്ടിക്സിനെ പറ്റിയും വളരെ സിമ്പിളായി നല്ല രീതിയിൽ മനസ്സിലാകുന്ന തരത്തിലുള്ള ക്ലാസ് അല്ലെങ്കിൽ ഒരു സെഷൻ സമ്മാനിച്ച ഡോക്ടർ വാണി കേസരി മാഡത്തിന് വനിതാ ശിശു വികസന വകുപ്പിൻ്റെ പേരിൽ എല്ലാവരുടെയും പേരിൽ നന്ദി അറിയിച്ചുകൊള്ളുന്നു.
Thank you. As we are moving on to the closure of this conclave, may I now take this opportunity to call upon Srimati Bindu Gopinath, the Additional Director of Women and Child Development Department, who has been the lady behind this 2-day conclave from the start till the end. Let's give a big round of applause to ma'am.
നമസ്കാരം. ഫസ്റ്റ് ആൻഡ് ഫോർമോസ്റ്റ് എൻ്റെ ടീമുണ്ട് ഇവിടെ. ഞാൻ മാത്രമല്ല ചെയ്തത്. ടു ഓഫ് ഓൾ മൈ ടീം WBC ടീം അത് ഐ വുഡ് ലൈക്ക് ടു താങ്ക്. മീൻവെൽ ഐ ജസ്റ്റ് ഗോ ഓൺ വൈ നമ്മൾ ഈ 2 ദിവസത്തെ പ്രോഗ്രാം ഓർഗനൈസ് ചെയ്തപ്പോൾ ജെൻഡർ ജസ്റ്റിസ് ബിയോണ്ട് ബയോളജി ആൻഡ് സോഷ്യൽ നോംസ് എന്ന് പേരിട്ടത് തന്നെയാണ് ഇത്. അത് വെരി റൈറ്റ്ലി മാഡം ത്തിൻ്റെ ടോക്കിൽ നിന്ന് നമുക്ക് മനസ്സിലാകാൻ പറ്റിയെന്നാണ് ഞാൻ വിചാരിക്കുന്നത്. ബിക്കോസ് നമ്മൾ വാട്ട് എവർ ഇറ്റ് ഈസ് അൺലെസ് വി ഗോ ബിയോണ്ട് ദ ബയോളജി ഓഫ് വുമൺ എല്ലാം ടൈഡാണ്. ആ ബയോളജിയാണ് സോഷ്യൽ നോംസുമായിട്ടും ടൈപ്പ് ചെയ്തിരിക്കുന്നത്. പല ബാരിയേഴ്സ് നമുക്ക് സ്ത്രീകളുടെ ഉന്നമനത്തിനായിട്ട് തടസ്സമായി നിൽക്കുന്നതും ഇപ്പോഴും ഈ ഒരു ബയോളജിക്കൽ ആസ്പെക്റ്റാണ്. ആ റിപ്രൊഡക്റ്റീവ് റൈറ്റ്സ് ആവാം. ആ റിപ്രൊഡക്റ്റീവ് റൈറ്റ്സ് എന്ന് വെച്ചിട്ട് അതിന് കണക്ട് ചെയ്ത് എല്ലാ ആസ്പെക്ട്സ് ബീറ്റ് അറ്റ് വർക്ക് കിട്ടുന്ന ജോലി കിട്ടുന്നതാണെങ്കിൽ മാഡം പറഞ്ഞു റൈറ്റ് ടു ലൈഫ്, റൈറ്റ് ടു വർക്ക്, റൈറ്റ് ടു ചോയ്സ് എല്ലാം ഈസ് കണക്റ്റഡ് to the biology of the woman. അപ്പോൾ നമുക്ക് when we thought of this subject, നമുക്ക് ലൈഫിൻ്റെ എല്ലാ ആസ്പെക്ട്സിലും ഇത് കിടക്കുകയാണ്. അപ്പോൾ നമുക്ക് ഇന്ന് 2 ദിവസം ഒരു ചർച്ച ചെയ്യുമ്പോൾ എന്തൊക്കെ ടോപ്പിക്സ് കൊണ്ടുവരാമെന്ന് വിചാരിച്ചപ്പോഴും നമ്മൾ വിചാരിച്ചത് 2 ആസ്പെക്ട്സ്. ഒന്ന്, ഇക്കണോമിക് ഇൻഡിപെൻഡൻസ് വന്നാലേ അത് ഒരു എന്താണ് ഉപാധിയാക്കി നമുക്ക് മുന്നോട്ട് സ്ത്രീയുടെ ഉന്നമനത്തിന് മുന്നോട്ട് കൊണ്ടുപോകാൻ ഒരു ഇക്കണോമിക് ഇൻഡിപെൻഡൻസിന് വേണ്ടി നമ്മൾ ഇൻക്രീസിങ് വുമൺ വർക്ക് പാർട്ടിസിപ്പേഷൻ ആയിട്ടൊരു ടോപ്പിക് ഇന്നലെ എടുത്തു. അതിൻ്റെ എന്തൊക്കെയാണ് ഓപ്പർച്യൂണിറ്റീസ്, എന്തൊക്കെയാണ് ബാരിയേഴ്സ് ഒക്കെ പറഞ്ഞ് ഡീറ്റെയിൽഡ് ഡിസ്കഷൻസ് നമ്മൾ ഇതിനെ നടത്തി. ഇന്ന് നമ്മൾ എന്താണ് ലെജിസ്ലേഷൻസ് ഫോർ വിമൻ, അതിൻ്റെ ന്യൂനതകൾ എന്താണ്, ഒരുപാട് സ്റ്റെപ്സ് പോസിറ്റീവ്. ഒരു വശത്ത് നമ്മൾ ഇന്ന് നമ്മൾ ഒരു 2-3 സ്റ്റെപ്സ് പോസിറ്റീവ് സ്റ്റെപ്സ് എടുത്താൽ ചിലപ്പം 2 സ്റ്റെപ്പ് ചിലപ്പോൾ പിറകെ വരുന്ന സ്ഥിതിയും ഉണ്ടാവാറുണ്ട്. ലോ അതിൻ്റെ രീതിയിൽ പോവുകയാണ്. അപ്പം നമുക്ക് ചെയ്യാൻ പറ്റുന്നത് നമ്മൾ മാഡം പറഞ്ഞ പോലെ ടാർഗറ്റ് ഇപ്പോൾ ഉള്ള യൂത്ത് ക്യാരി ദ ടോർച്ച് ഫോർവേഡ്. പണ്ട് ആൾക്കാർ നമുക്ക് സ്ത്രീകൾക്ക് വേണ്ടി, സ്ത്രീകളുടെ ഉന്നമനത്തിന് വേണ്ടി ജോലി പ്രവർത്തിച്ച ആൾക്കാരുടെ പ്രയത്നത്തിൻ്റെ ഫലമായിട്ട് നമ്മളിവിടെ നിൽക്കുമ്പോൾ നമ്മളുടെ കടമയാണ് ഇന്ന് ഇത് ടേക്കിംഗ് ദ ടോർച്ച് ഫോർവേഡ്, സോ ദാറ്റ് കമ്മിങ് ജനറേഷൻസ് ഇറ്റ് ഷുഡ് നോട്ട് ഗോ if everything goes home within, hopefully at least within some 50 years time things will change and that woman will be an equal partner in സൊസൈറ്റി ആയിട്ട് പ്രവർത്തിക്കാൻ പറ്റുമെന്നുള്ള വിശ്വാസം. അപ്പോൾ ഒന്ന്, ഇൻഡിപെൻഡൻസ് വർക്കിൻ്റെ ആസ്പെക്റ്റിൽ നമുക്ക് മുന്നോട്ട് പോകാം, ഇക്കണോമിക് ഇൻഡിപെൻഡൻസ് വരും. അതുവരെ അതിലൂടെ സ്ത്രീക്ക് എന്താണ് അവരുടെ പ്രസൻസ് ഇൻ സൊസൈറ്റി ഇൻവിസിബിൾ അല്ലാതെ, ഇപ്പോൾ നമ്മൾ ഇൻവിസിബിൾ അല്ല, പല ആസ്പെക്ട്സിൽ പെടുന്ന ഇൻവിസിബിൾ ആണ്. ഹയർ എക്കണോമിക്സ്, ഹയർ പൊസിഷൻസിൽ ഇലക്ഷനിൽ മാഡം പറഞ്ഞു എന്താണ് പോപ്പുലേഷൻ കൺട്രോളിൻ്റെ ഭാഗമായിട്ട് 2-child norm കൊണ്ടുവന്നു. ബട്ട് ദാറ്റ് ഈസ് എ ബാരിയർ ഫോർ വാട്ട്, ഫോർ വുമൺ ടു കം അപ്പ്. ദാറ്റ് ഇറ്റ് സെൽഫ് ഈസ് ബിക്കമിങ് എ ബാരിയർ. അപ്പോൾ നമ്മൾ സിസ്റ്റമിക് ആയിട്ട് തന്നെ അറിയാതെ കുറേ കാര്യങ്ങൾ വേറെ എന്തെങ്കിലും ഉദ്ദേശം ലക്ഷ്യമിട്ട് ചെയ്യുമ്പോൾ അത് എങ്ങനെയാണ് സ്ത്രീയെ ഇമ്പാക്റ്റ് ചെയ്യുന്നതെന്ന് പലപ്പോഴും ശ്രദ്ധിക്കാതെ പോകും. അത് ആ ഒരു ജെൻഡർ പോളിസി മേക്കേഴ്സും ഒക്കെ ഒരു ജെൻഡർ ലെൻസോടെ അതിൻ്റെ കോൺസിക്വൻസസ് നോക്കി ചെയ്തിരുന്നെങ്കിൽ ഈ ഒരു ഇത് വരില്ലായിരുന്നു. ബട്ട് നൗ we have to address that. ഒരു ഇഷ്യൂ അഡ്രസ്സ് ചെയ്യാൻ എടുക്കുന്ന ഒരു മാർഗം അത് വേറൊരു രീതിയിൽ സ്ത്രീയുടെ ഉന്നമനത്തിന് തടസ്സമായി നിൽക്കുന്ന ഒരു സ്ഥിതിവിശേഷമാണ് വരാറ് പലപ്പോഴും. ആരും മനഃപൂർവ്വം ചെയ്യുന്നതല്ല, ബട്ട് ഇറ്റ് ഹാപ്പൻസ്. ബട്ട് അതാണ് നമ്മൾ ഇനി എന്താണ് ഇങ്ങനെ ഇത് നമ്മൾ ഈ 2 days സെമിനാർസൊക്കെ ചെയ്യുമ്പം ഒന്ന് നമ്മൾ ചെയ്യുന്നത് നമ്മൾ ഈ മേഖലയിൽ വർക്ക് ചെയ്യുന്നവർക്ക് കൂടുതൽ അറിവുണ്ടാക്കുക. രണ്ടാമത് വരും തലമുറ അല്ലെങ്കിൽ ഇപ്പം പഠിച്ച് വളരുന്ന ഓരോ മേഖലയിലുള്ള ആൾക്കാരുണ്ട്. ഇക്കണോമിക്സ് നമ്മളിവിടെ ക്ഷണിച്ചത് ഇക്കണോമിക്സ് മേജേഴ്സിനെ വിളിച്ചു, അക്കാഡമീഷ്യൻസിനെ വിളിച്ചു, പൊളിറ്റിക്കൽ സയൻസ് സബ്ജക്ട്സ് ഡീൽ ചെയ്യുന്നവരെ വിളിച്ചു, സൈക്കോളജി, ഡെമോഗ്രഫി സബ്ജക്ട്സ്, ലോ, എന്താണ് ഈ നിയമമൊക്കെ ഇനിയും ഭാവിയിൽ ഇത് മുന്നോട്ട് ഇൻ്റർപ്രറ്റ് ചെയ്ത് മുന്നോട്ട് കൊണ്ടുപോകാനുള്ള ആൾക്കാരാണ്. അപ്പോൾ ഇവരെല്ലാവരും വിളിച്ച് നമ്മളെല്ലാവരുമായിട്ട് ഒരു കൂട്ടായ്മയോടെ ഒരു ചിന്തിക്കാനാണ്. ഇത് ബൈ ടുഡേ നത്തിങ് ഈസ് ഗോയിങ് ടു ഹാപ്പൻ, ബട്ട് വി ക്യാൻ ബ്രിങ് അബൌട്ട് മൈൻഡ് സെറ്റ് ചേഞ്ച്. ആ ഒരു ഉദ്ദേശത്തോടെയാണ് നമ്മളിവിടെ എല്ലാവരും നിങ്ങളെല്ലാവരും വിളിച്ചത്. ഐ ഹോപ്പ് ഇറ്റ് വാസ് യൂസ്ഫുൾ ടു ഓൾ ആൻഡ് വൺ ആൻഡ് ഓൾ. ഒരുപാട് ഇറ്റ് വാസ് നോട്ട് പെർഫെക്റ്റ്, ഐ വോണ്ട് സേ ദാറ്റ്, ബട്ട് ഓൾ അവർ സ്പീക്കേഴ്സ് ആർ പാഷനേറ്റ് in whatever subjects they discuss with you. എല്ലാവരും എൻ്റെ ചെയ്തത് മാഡം വാണിയ കേശ്രീ മാഡമാണ്. ശിവ മാഡം സ്പോക്ക് ഓൺ വർക്ക് വർക്ക് ലോസിനെ കുറിച്ച് രാവിലെ തൊട്ട് മാഡം വന്നിരുന്ന് ഷി വാസ് ലുക്കിംഗ് ത്രൂ. എലിസബത്ത് മാഡം ഓൾസോ സ്പോക്ക് വെരി ഫോക്കസ്ഡ് ആയിട്ട് പറഞ്ഞു. എന്താണ് ആക്ടിവിസ്റ്റ് മോഡിലാണ് മാഡം പറഞ്ഞത്. ഹൗ ടു ഗോ അബൌട്ട്, വി ഹാവ് ടു ചേഞ്ച്, സെറ്റ് ദ അജൻഡ. കംപ്ലേസൻ്റ് ആയിട്ട് ഇരിക്കാൻ പറ്റില്ല എന്നുള്ള കൗസസ് ആർ ലിമിറ്റേഷൻസ് ഓഫ് ദ ലോ, വാട്ട് ക്യാൻ ബി ഡൺ എന്ന് സംസാരിച്ചു. ശോഭ കോശി മാഡം അഗെയിൻ 61 ഡൗറി പ്രൊഹിബിഷൻ ആക്ടിനെ കുറിച്ച് പറഞ്ഞു, PWDV ആക്ട് കുറിച്ച് പറഞ്ഞു. ഇതൊക്കെ നിയമമുണ്ട്, അത് മൈൻഡ് സെറ്റ് ചേഞ്ച് വന്നാൽ മാത്രമേ മുന്നോട്ട് സൊസൈറ്റി ആസ് എ ഹോൾ കൊണ്ടുപോകണം. ഒരു പൗരൻ്റെ ദൗത്യമാണ് എന്നുള്ള രീതിയിൽ. ആർട്ടിക്കിൾ 50 നമ്മളെപ്പോഴും റൈറ്റ്സിനെ കുറിച്ച് പറയും, നമ്മൾ പൗരൻ്റെ കർമ്മത്തിനെ കുറിച്ച് പറയാറില്ല. ആർട്ടിക്കിൾ 51A(e) എങ്ങനെയാണ് പറയുന്നത് മാഡം? it says fundamental rights and മാത്രമല്ല fundamental duty of a citizen is to denounce all forms of practices derogatory to women. നമ്മൾ എത്ര പേര് ചെയ്യുന്നു? അങ്ങനെ നമ്മൾ ഓരോ പൗരനും തീരുമാനിച്ചിരുന്നെങ്കിൽ ഇന്ന് ഡൗറി കാണില്ലായിരുന്നു, ചൈൽഡ് മാരേജ് നടക്കില്ലായിരുന്നു, ഒരു സ്ത്രീ ജോലിക്ക് പോകാൻ തടസ്സമായിട്ടുള്ള സാഹചര്യം ഉണ്ടാവില്ലായിരുന്നു, സമൂഹത്തിൽ മാറ്റം വരുമായിരുന്നു, അവർ സ്ത്രീയെ ഇൻഡിവിജ്വലായിട്ട് റെക്കഗ്നൈസ് ചെയ്യുമായിരുന്നു. അപ്പം ഓരോ പൗരൻ്റെയും ദൗത്യം, അത് ആണായാലും പെണ്ണായാലും, ആ ഒരു മെസ്സേജാണ് നമുക്ക് കൊണ്ടുപോകാൻ. അങ്ങനെ ഒരു പൗരൻ ഒരു വിതിൻ ദ സിസ്റ്റം മാത്രമല്ല ആൾക്കാരുടെ ഇടയിൽ, കുട്ടികളുടെ ഇടയിൽ ആ ഒരു മാറ്റം വന്നാൽ ജുഡീഷ്യറി നമുക്ക് ഒരുപാട് ചേഞ്ചസ് കൊണ്ടുവരുന്നുണ്ട്. അവരെ ഇൻ്റർപ്രറ്റ് ചെയ്ത് നിയമങ്ങളിൽ ന്യൂനതകൾ പരിഹരിക്കുന്നു. അതിനോടൊപ്പം നമ്മൾ ഈച്ച് ആൻഡ് വൺ ഓൾ സിറ്റിസൻസ് ഓഫ് ദ കൺട്രി നമ്മളും ആ രീതിയിൽ അത് ഫോളോ ചെയ്താൽ, നമ്മളെ ഫണ്ടമെൻ്റൽ ഡ്യൂട്ടീസ് ക്യാരി ഔട്ട് ചെയ്താൽ മാറ്റം സ്പീഡപ്പ് ഈ 50 വർഷമൊന്നും കാത്തിരിക്കേണ്ടതില്ല. അപ്പം I thank you all, with everybody, all our eminent speakers, Madam Shibama, Madam, Vani Madam, നേരത്തെയുള്ള വന്നു പോയി എല്ലാ സ്പീക്കേഴ്സിനെയും പിന്നെ ഇവിടെ ഇരിക്കുന്ന എല്ലാവർക്കും ഒറ്റ വാക്കിൽ നന്ദി പറഞ്ഞ് നിർത്തുന്നു. താങ്ക് യു.
Thank you, ma'am. With this, we are concluding this 2-day conclave organized by Women and Child Development Department in association with Women and Child Development Corporation under the Government of Kerala. Let me take this opportunity once again to thank all of you who had been a part of this program. May I thank the distinguished speakers and the resource persons who have shared their knowledge and experience in the field to make us a better understanding on the women's rights and legislations as well. Thanking all the participants and delegates for the thoughtful and insightful interactions which has made these sessions lively. And thanking all the coordinators, organizers, volunteers who had been working seamlessly behind the scenes for a smooth conduct of the conclave. Wishing you all a very good luck. This is Sukanya Jairam. Take care.